मैं फ्री हो रहा हूँ
Yes.
like to mention an all matter today हमारे some urgency matter
This bench. What matter?
it's an eviction matter that my talk to be evicted my lord when lands are not covered by the decree matter
Now you filed what?
here
CRP. Tomorrow we'll have? Okay.
and
Have you filed it or not?
yes man no problem
Okay.
I will have it tomorrow I'm just giving the filing number after that.
Tomorrow, yes.
Please take mention item number 4
Yes.
can the fix off on 20
You're for...
540
Okay. When do you want?
28 on Friday.
Friday it'll be rush. We don't know. Okay, we'll fix it. Okay. You're for the respondent, Guwahati University. On a prayer made on behalf of the respondent, matter is adjourned to be listed on Friday date. Item 4.
With respect to mention for listing of an urgent matter day after tomorrow.
New matter.
New matter.
May I please alert I beg to mention for listing to MSc appeal on Wednesday.
New matter.
Right.
Fresh.
Freshman
When did you file?
on 21st.
What is the urgency? MSc appeal?
Alertive in the meantime, they have filed one Baki Jai case.
Okay. But there will be a condonation of delay. That
No
means
alertive, no delay.
no delay.
No delay.
Okay.
With the consent of the other side, I beg to mention item number 10 and 28.
Yes.
Both in both the cases, I have put appeal and lordship. These matters may come any day after vacation.
10.
10 and 28.
Okay. Here for whom?
I have put appellant. I have taken the consent.
10. Here with Madam Mozumdar?
Yes, Lord.
Okay. On a prayer made on behalf of the appellant. Matters are adjourned to be listed after the summer vacation. 10/28.
Sorry. A regular first appeal. Maybe I have filed on 3rd of June.
Fresh matter?
Yes.
There's no urgency in the first appeal.
Because
Okay, we'll have it Wednesday.
not Wednesday, Thursday or Friday. Wednesday, Mr. Ekupukesh will not be here. He is some.
Okay, Thursday.
Much. May I please alert? By my instruction, the distance between the house of the respondent and the Karimganj town is 38 kilometers. And the distance between his house and Hailakandi town is 29 kilometers. So my lord, Hailakandi is nearer, my lord.
28 kilometer, 29 kilometer, 38 kilometer. What is the difference?
But from my house, my lord, to Karimganj house, Karimganj it is 52 kilometers. And 2 cases are already in Hailakandi court.
In all cases, you cannot come for transfer like this. You have to travel to the court at Hailakandi also. 28 kilometers. Whether you travel 28 kilometers or 60 kilometers, it's not a matter of 1-2 kilometers that you are, for one court, you are traveling for 2 kilometers, the other 40 kilometers.
My lord, I'm staying in my parental house, and from my house to Karimganj.
Petitioner is the wife.
Yes, no, my lord, my husband, my lord.
Petitioner is the wife presently.
Yes,
What is the proceeding you are seeking transfer?
my lord, so it is divorce proceeding, my lord.
Respondent instituted where?
In district judge Karimganj, my lord.
Then?
My lord, and 2 cases, my lord. Hailakandi, my lord, it is pending, my lord. If one is TB case number, my lord, 87 of 2022, and one maintenance case number, my lord, CRPC 125 proceeding, MR case number 83 of 2020. Both these cases are pending before my lord of Hailakandi, my Chief Judicial Magistrate Hailakandi, my lordship, that is TV case number. And MR case number is also a Chief Judicial Magistrate pending, and both are in evidential stage, my lord.
This divorce suit is of the year 2023.
Yes, my lord. Now I have got the notice, my lord.
You have filed your written
No, my lord.
statement.
26 is my appearance. 26th of June, my lord.
You want to transfer to
Hailakandi, District Judge Hailakandi.
from Karimganj to Hailakandi.
Hailakandi.
What is the distance from your place to Hailakandi?
From my place to District Karimganj,
You
my
are
lord,
having any issues?
my lord, yes, my lord. One female child.
One daughter.
Yes. She is with me. Her custody is,
How old?
she is 6 years old now.
And you are living where?
In my parental house,
Who are there?
my lord.
Who are there in the parental home?
My father, mother, parent.
Parents.
Yes.
What is your source of income?
I don't have any source of income.
How much maintenance is being paid?
I'm not getting any. My maintenance proceeding is going on.
125 proceeding you have started.
Yes, my lord.
What are the grounds of divorce?
My lord, my only ground that
What are the grounds of divorce?
my lord, divorce is that my husband's allegation is that I'm not cooperating. And
Now
we went,
that would not be a ground. Ground has to be within those grounds which are
I left the
Understood you.
house without any reason.
desertion.
Yes.
Since when?
My lordship, since 23 2019. No, not my lordship. 5/6/2019. 5/6/2021, my lord. Sorry. 5/6/2020.
When was the marriage?
My lord, marriage was solemnized on 19/2/2008.
Why did you come out of the matrimonial
My
home?
lordship, first we went to Calcutta, my lordship. He took me to Calcutta. And there, my lordship, from there again we came to Karimganj, my lordship. And due to, I have filed also complaint case against the physical torture and mental torture. That these are the allegations which I have leveled against him, my lordship. And therefore he posted me, and I, along with my child, took shelter in my parental house.
Where?
In my parental house in Hailakand.
No, you see, you have deserted, the allegation is of desertion since June 2021.
5/6/2021.
June 2021.
Yes.
You had left the matrimonial home.
Yes, my lord.
So what are your grounds of?
My allegation is that he hosted me, and his allegation is that without any reason I left because
Okay, when did you institute DV case?
my lordship, I instituted DV case 2022, my lordship, and MR case also 2022.
MR case is okay. DV case 22.
22, my lord. After I was hosted from matrimonial.
You were ousted in June 2021.
Yes, my lord.
You instituted DV case in 2022.
2022.
And what is the distance from your house to Hailakandi?
My house to Karimganj, my lordship, Hailakandi town to Karimganj, my lordship. It is
No,
53
from your house.
Yes, my lord. My house is in Hailakandi town.
Yes,
And from Hailakandi town to Karimganj is 53 kilometers.
53.
And from his house to Karimganj is, my lordship, 38 kilometers.
To Karimganj.
Yes, from respondent house to Karimganj.
Okay, now, and your, how far is your house from the courts at Hailakandi itself?
My lord, this is same town, my lordship. I am also living in the town, and the court is also in the same town. My lord, his distance between his house and Hailakandi.
No, you need not think about him. He has not come for transfer. He has instituted in a place where it suits him. He's the dominus litis. It's his choice. What about the option of video conference?
Right.
If you are citing only the difficulty of going there without any other grounds, you can have for video conference. Third, 3 S.B. Laskar, Learned Counsel, for the petitioner who has instituted this petition under section 24 of the Code of Civil Procedure, praying for transfer of title suit within bracket divorce number 129 of 2023 from the court of the Learned District Judge Karimganj to the court of the Learned District Judge Hailakandi. Full stop. The petitioner is the second party wife in the divorce proceeding. Full stop. Para. It is contended that the petitioner has in the meantime filed to, in the meantime, has in the meantime filed, filed 2 cases at Hailakandi against the respondent -1 under the Domestic Violence Act and the other under section 125 of the CRPC for maintenance. Full stop. The Learned Counsel has also highlighted the aspect of the distance of about 53 kilometers from her parental home where she is staying to the court at Karimganj.
Yes.
Full stop. Para. Let notice be issued returnable on on 22nd of July 2024. Let steps be taken for service of notice be taken by registered post with AD. Steps within 2 days. Full stop. Para. The prayer for interim order would be considered on the next returnable date. Full stop. The aspect of the Learned Counsel is also directed to obtain instructions on the aspect of appearing through video conference. You take steps immediately. Can you take steps by Dusty?
Yes, my lord.
Possible.
You can try, my lordship.
We give an observation
Yes.
additionally. Huh? He is given liberty, Bulikoba. Okay. But you have to file affidavit before the next date.
Yes.
And Dusty to be routed through the registry.
My lord, on 26, I have,
The next date is, we are fixing it on 22nd of July.
and the case, the case,
26th you appear there. You can apprise the court about this order. And he will also know, 26th you can serve. Okay, next. Azik Manhol. 24th. Oh, photo hai. Okay.
highly
We'll get the order today itself. We'll get the online copy of the order today itself.
highly okay.
Yes.
My lordship.
Yes, please.
During the pendency of a suit, my lord,
You are
I am for the contesting defendant.
suit for,
Defendant 1 to 4.
suit for,
Suit for declaration, cancellation of sale deed, challenging our deed. Now, we have filed our written statement, my lord.
yes.
Then, during the pendency of the suit,
Hmm.
the plaintiff has filed an application on 3rd of June 2024
Hmm.
for withdrawal of the suit, saying that that they have no claim against the defendant,
Against you.
against the defendant, all the defendants. That application was filed on 3rd of June 2024.
Hmm.
On the next day, that is on 4th of June
Hmm.
2024, defendant number 7 and 9,
Hmm.
they filed an application for transposing them to in the place of the plaintiff.
Under what provision?
Under Order 23, Rule 10A, they have mentioned, but it ought to be 1A. 1A says, my lord, that if the defendant having a substantial question against other defendant, they may transpose. There is no confusion on that part.
Hmm.
But that application was filed without implementing any of the defendants, only implementing the plaintiff in the application. So we are not in the arrayed as a party in the application. That application was registered as a miscellaneous judicial, being number 152 of 2020.
152 of
2020.
24.
Mistake case number 120.
Yes.
Now, by the impugned order, in that mistake, the learned civil judge Dibrugarh has allowed the applicants transposing them in the place of plaintiff.
Which order?
The impugned order is dated 13/6/2024. 1306/24. Page 59. And by an order on the same day, in the title suit, the application of the plaintiff for withdrawal of the suit, that was allowed. So if the suit was allowed, withdrawal application was allowed, there is no suit. So therefore, there would be no question of transposing of the plaintiff. This is one point to be adjudicated by this.
No, that can be rectified. His
That
name can be struck
now-
off. But
now-
the first substantial point,
Yes.
when on transposition, the lease becomes one between the defendant numbers 7 and 9 and you.
Yes.
Under those circumstances, whether you ought to have been given an opportunity before transposing them. That's the
Yes.
question you are.
That is a question. And second, the learned court below also directed them to file pleadings, press pleadings. That is not permissible. Because the transposed plaintiff, they are required to travel within the parameter of the pleading as pleaded in the plea. And their application also reflected that contention that we support the case of the plaintiff. And since we support the case of the plaintiff, therefore we are not instituting a separate. So for the transposition part is concerned, my lord, they have a right. There is no dispute in the law. They are having a right. But that ought to be by hearing all the parties. And secondly, press pleading cannot be permitted. Basically, on these two counts here before this.
Any rulings on the other ground?
I have such lordship that so for the press pleading is concerned, I have not found any case law of our High Court or the Supreme Court. We have find out a case law of Patna High Court. Patna. Supreme Court in a recent judgment says that you can transpose, no problem. That is in 2020 judgment. Paragraph 12, 13 and 14. Lord, you will find after 4-5 line. Apart from that, a defendant on being transposed as plaintiff can only agitate the matter within the parameter of the suit as originally is. he cannot make out a absolutely new case with a new relief based on a new cause of action. And order 23 rule 1A also does not permit, because Lordship is aware that pleading is under chapter 6 of the Code of Civil Procedure. And only the provision for additional pleading, that is order 8 rule 9. Patna High Court judgment paragraph 14 also relevant. Last part. Transposition cannot be permitted.
What is this Sarguja transport of 87
My lord?
Supreme Court? Sarguja transport?
Yeah. Hey, Supreme Court. Also. Huh.
87, I think.
This is 2020, my lord.
No. There's 87 Sarguja.
Oh, this Patna High Court.
No. Supreme Court. Patna High Court is Ashok Chaudhary.
Yes.
On 23-1, I think there's
Yes. This
there is a reference in the judgment.
Yeah. But the Supreme Court in 2020 says, Your Lordship, that if they having a substantial interest, then without a multiplicity, avoid multiplicity proceeding, they may transpose.
No, that is okay.
There is no dispute. There is no.
Okay.
Lord.
Heard Sri B. Dr. and Senior Counsel assisted by Sri S. Dekka, who by means of this application filed under Article 227 of the Constitution of India has put to challenge an order dated 13/6/2024 passed by the learned civil judge, Dibrugarh, senior division,
Senior.
Dibrugarh, in Meet J case number 152 of 2024 arising out of title suit number 155 of 2023, full stop, by the aforesaid order, the application of the defendant numbers 7 and 9 in the suit for transposing them as plaintiffs was allowed, full stop. Further, the said defendants on such transposition have been allowed to submit fresh pleadings, full stop. It is also contended that in the aforesaid Miss J case number 152 of 2024, comma, the petitioner, the present petitioner, who was the contesting defendant, was not made party. Full stop, para. The learned senior counsel has submitted that while the provisions of Order 23, Rule 1A of the CPC envisages stipulates for such transposition, comma, the suit would continue on the basis of the existing pleadings and not by separate pleadings. Full stop. The issue that the petitioner was not made a party in the said application has also been highlighted. Full stop. Para, let notice be issued returnable on 26th of July 2024. Last steps, registered posted AD within 2 days on all the respondents. Para, heard the learned counsel on the interim prayer, full stop. Upon hearing and in the interest of justice, this court is of the opinion that after hearing, this court is of the opinion that interest of justice would require staying of further proceedings till the next returnable date. Full stop. Accordingly, further proceedings in title suit number so and so before the learned civil judge senior division, Dibrugarh, shall remain suspended.
Clear to you.
Para, the interim order, however, would be reconsidered on the returnable date.
Good.
Appeal for enhancement of the awarded amount. Episode notice may go and LCR may fall.
There was delay condemnation.
Or Lordship, delay was condoned also.
That is why 18 matter.
Sir. Delay was condoned on 27/24.
KK Datta,
Yeah.
heard Sri KK Datta learned counsel for the appellant who by means of this application, means of this appeal filed under section 173 of the Motor Vehicles Act has challenged the judgment and ordered it so and so, full stop. The grievance of the appellant is towards the adequacy of the amount involved. Full stop. Admit, call for the records. Yes, Mr. Goswami. For one. Mr. Chaudhary, you had appeared. You appear, take notice. Sri Goswami, learned counsel, appears and accepts notice on behalf of respondent number 1. And Sri A.D. Chaudhary, learned counsel, accepts notice on behalf of respondent 5 and 6. Let extra copy of the memo of appeal along with the enclosures be served upon them. Let steps be taken for the respondent numbers 2, 3, and 4 by usual process. Steps within 2 days. The names of Sri R. Goswami. Oh, your name is also there. The names of Sri A.D. Chaudhary, learned counsel, may also be reflected in the cause list.
Yep.
List after 6 weeks, along with report on service. LCR code, sir. Enhancement.
Enhancement, my lord. If there was a delay that has been condoned.
Okay, and you are for?
I'm for expert number one. And I that's really reflected in the court.
RD Mazumdar?
Yes.
Okay, same over, huh? Madam Mazumdar would be appearing for whom?
Expert number one.
One. And Mr. Come to your area of titles 2 and 3, page 2 and 3,
My lord,
page 2.
my lord.
Page 2 is the area of parties thereafter. Page 3. Page 3, you write again the parties in the MSA case. And you see how what numberings have you given?
So that is, my lord,
Why do you have to write the number, the area of parties of the MSC case?
not recorded.
This is an appeal, you are not required to write.
Well.
And the numberings also see 4, 5, 6, from where 4 has come. Don't add confusion. You have to place your matter as simple as possible before
Well,
the court.
sorry.
One, your name?
SP sir.
S.V. Sharma, for accepts notice on behalf of RD Mazumdar. 2 and 3 registered, usual process within 2 days. Admit records.
Can I have the liberty to paper public?
No, not at the immediate stage. You
Notice
take-
was issued, my lord, by order dated.
No, that was in the condemnation petition.
My lord.
Here you take notice, usual process. Okay.
Well-
And if it's,
On 13/2/2023, my lord, in the main case,
was it admitted? No.
not at.
No, notice is issued. Here notice was issued
Notice was issued, my lord.
in the appeal.
Yes, well. After condemnation of step,
No, where is the provision of issuing notice in an appeal?
it should come, actually, it should have come in order column, my lord.
No, why order column? It has not been admitted.
My lord, my lord.
This is statutory appeal, has to be admitted. Okay, কি কয় admit লাষ্টত যে ক'বা step নহয় সেইটো হ'ব সেইবিলাক চব থাকিব শ্ৰী Roy, Roy, the learned counsel has informed this court that by an order dated 13/2/2023, notice was issued. And though this notice was issued, and as per office note dated 19/4/2024, comma, the notices, and again see here they have seen 3 and 4. Obviously they'll say 3 and 4. Your numberings are notices are reports of the upon reports on the notices are incomplete. Full stop. The learned counsel accordingly prays for serving notice by registered by paper publication. You have instructions.
Yes.
Para. Let notices upon the respondables 2 and 3 be served by paper publication, which is to be done in one edition of the Assam Tribune and another edition of the Doinik Akhom. Full stop. The notices are to be vetted by the registry of this court. And prior to the next date, comma, an affidavit annexing the copies of the concerned newspapers are to be is required to be filed.
The name of my signature.
Okay, আৰু অকমান লম্বা দি দিওঁ. We'll make a further date. আমি কিমান কৈছিলো 26 কৈছিলো ন? Don't put 26, then we put 31st of July. You have some more days. 31st of July. Name of
RD.
MS RD Mazu, be reflected. Okay.
Apology. an appeal under section 82.
Item number
Three.
3, yes,
Appeal under section 2 of the ESC.
okay.
There was a delay.
Where are your substantial questions?
Substance because of, I have stated in my ground for that and also a different
Which of the grounds?
page. Page 2, my lord. Counts 1, 2, 3, and 4.
Yes, I see a concern. Employee state insurance. What is your first ground?
The first brought whether the first insurance court having come to the observation that the establishment of the respondent comes within the purview of the ASI Act. In that case, they seem to be in continuance unless and until the exemption has been granted by the state government.
Now, why have you quoted section 1(6) of the Act?
And because in section 1(6), my lord, once the establishment comes under the
Let us read 1(6).
my lord, the factory or establishment to which this act applies shall continue to be governed by this act, notwithstanding the number of persons to be notwithstanding the number of persons employed therein at any time falls below the limit specified by or under this act, or the manufacturing process therein is to be carried on with aid of power.
Hmm.
So once the establishment falls within the purview of the ASI, it will be deemed to be in continuance.
Whether there is less numbers of employees or not.
Unless my lord, the exemption is granted under section 88.
So what is your contention?
And a contention when the issues were framed by the court on page 5, my lord. The three issues, whether the petitioner establishment comes within the purview of the ESI.
No, on facts, what do you say? They had pleaded that the numbers of employees were less than the prescribed
They
number.
have not disputed that, my lord. The only issue remains that the notice, my lord, the section 45A, they have pleaded that they have not received the notice. But whereas in their own petition under section 75, they have in paragraph 9 and 12.
So why have you framed the first question if there is no dispute on the
But-
continuance of the coverage of this act, notwithstanding the fact
But-
that the number of employees was less than the prescribed period or the manufacturing activities were stopped unless there is an order of exemption?
But-
Was that the issue?
But the issue was there, but at page 5, my lord, the issue was framed.
Yes.
But at page 5 of the,
Now, is there any content? Is there any dispute with that issue?
well, they have contested the dispute, but the TI court has given this issue in favor of the corporation.
So why is this a substantial question? It's your appeal.
Well, the question here, my submission.
No,
The-
second notice question is okay. We'll frame it. First question, from the judgment, we find that the coverage is not an issue.
well, then,
Second question. Now, if you say that coverage is the issue, you have to show from the judgment that coverage was the issue and the court has held that it was not covered. Has it been held? I
no,
don't,
the court
let
has
us, see,
already,
let us see that issue, how is it decided?
page
In-
10 of the
in-
appeal,
Internal page,
page 10.
Internal page.
6, paragraph 10,
what is the issue, whether to be covered?
my lord.
Therefore, it can be held the petition is covered, so there's not an issue to
Well,
be
then
decided.
that-
That is why, don't read. Unless they come up in an appeal,
Madam.
They can raise this question,
Madam.
not you.
Madam.
And regarding the notice, don't you think that these are all factual disputes after evidence?
No, madam, but the fact is, madam, that once they are bound to pay the ESI contribution. That's why the optional for it.
And the
Like,
third
by
one,
having with that,
third one,
madam,
see,
But
this,
the-
Mr. Smith, this is not a normal appeal. This is an appeal under a particular special act which requires substantial question. Though it's in the nature of a first appeal, but the purpose of the objective of the legislation is to lessen as far as possible any further interference and questions of fact. Okay, देखो. Third, three. Heard Sri M. Smith, Learned Counsel for the appellant, which has preferred the present appeal under Section 82 of the Employee State Insurance Act 1948 against a judgment and order dated. Ever side of, huh? Page 2. Para. It is submitted that the findings of the learned court below on the aspect of notice is contrary to the materials on record. Full stop. Para. Admit. Para. Call for the records. No, admit this appeal on the following substantial question of law. ये दुई नम्बर छ हाँ अरे ऐसे separate sheet दुई एटाই হ'ব নম্বৰ নিদিব আৰু हाँ call for the records. Para, let steps be taken for
that there was the IA matter, and we have already issued that, but yet they have not appeared.
IA is a different matter. Let steps be taken for service of notice upon the respondents by usual process. Steps within 2 days. List after 6 weeks along with report on service. क्या नाम क्यों लिखवाना है ये? पीछे क्यों नाम लिखवाना है ये? None appears for the appellants on call, full stop. However, because this reflects that the names of the council have not been reflected, full stop. Para, list again on Wednesday by reflecting the names of the learned council for the appellants. अरे चंदन কোৱাচোন এইটো কিয় দেখুৱা নাই মই চাইছো অকালতামৰ নাম চাম দিয়া আছে চব ফাইন কৰা নাম দেখুৱা নাই জাষ্ট এটা কৈ থৈ দিব এতিয়া Mr. Goswami, what is this?
Appeal has been filed, Lord. You understand, there have been some discrepancy, some contradictions in the evidence. Will be admitted, subject to deposit of 50% with security.
That case. That
That case.
case. Okay. Mondal, you are appealing for whom?
1 to 4,
1 to 4.
all the claimants.
Okay. Heard Sri R. Goswami Learned Counsel for the appellant who has preferred this appeal under section 173 of the Motor Vehicles Act against it will first page or para. What are your main grounds?
Discrepancy in evidence for the date of the accident.
It is contended that the impugned judgment is contrary to the materials on record, especially with regard to the date when the accident was alleged. Full stop para. Admit para. Call for the records. Call for the LCR, huh? Sri D. Mondal, Learned Counsel, appears and accepts notice on behalf of respondents 1 to 4.
1 to 4.
1
No, sir.
2 4.
6 statement 5 and 6 again it was the
Okay. Let extra copy of the memo of appeal along with the enclosures be served upon him within 2 days. Full stop. Para.
Sir,
Already served. Na, eto na lage. Sri Mondal submits that copy of the memo of appeal has already been served upon him. Para. That steps be taken for service of notice upon the respondents 5 and 6 by usual process. Steps within 2 days. List after 6 weeks along with service report. Para. In the IEU, right? Heard Sri R. Goswami Learned Counsel for the applicant appellant who by means of this application has prayed for stay of the operation of the impugned judgment. I go to her, insurance, pass by insurance. Para. The connected appeal has been admitted today. Full stop. Para. In the interest of justice, pending disposal of the appeal, the impugned judgment and so passed by shall remain suspended, subject to deposit of 50% of the award in the registry of this court. Full stop. Appeal, I stands disposed of.
the lordship, lordship granted.
As and when the amount is deposited, the respond number,
1 to
the
4.
claimant respondents may make an may make a prayer for release of the same.
Your lordship, prayer means then again I have to file an IA.
Not
But-
necessary. You list it. One deposit, make a mention memo. We'll grant you. Don't worry. Let them deposit. Once they deposit immediately.
Obliged.
We will not insist on an application.
Right, Teacher Lord. So this is an appeal filed by the New India Essence Company Limited, Lordship, mainly on the ground that Lordship, your Lordship, the learned member did not at all consider the search sheet which was against the driver of the tractor. And accordingly, held that both the vehicles are involved in that, both the vehicles are liable to pay compensation, and 50-50 was granted, Lordship. Whereas, as per search sheet, Lordship, it was against the traffic, so 100% would be against the traffic. That is our
It's a death
main
case.
ground.
Death case.
That case, Lordship. And secondly, one more point.
How much is the award?
Award was Lordship 13,88,844.
Yours is 50%.
That
And
is-
the other
has
50%
been
have
paid,
to,
Lordship.
the other insurance company has paid.
Yes, Oriental Insurance.
Okay, you are for which insurance?
I
New
am for
India.
the New India for the ambulance, Lord, where the disease was prevailing, Lord. And stop, Lordship, without any signal, reproduction negligence, applied the hard brake. Lord. And investigating officer also, Lordship.
Difficult.
I the-
Yes, you are for? You have already paid.
We have
No, the other insurance company, you have paid.
Appeal, no appeal was.
Okay. But you'll have a major stake here because once they are praying for that entire liability should be cast upon you. So you'll definitely, more than the claimants, I think you will be the aggrieved party. You have not otherwise challenged the amount. You're only challenging the apportionment.
Lordship, apportionment, and one more point we have taken the ground, that is 40%, he was a self-employed person, the deceased. As per decision of Honorable Supreme Court Lordship, it should be, he is aged about 27 years, it should be 40% instead of 50%, that is the one.
Regarding
Regarding this
40% of future prospects.
future prospect. Because he was not a
Those-
government employee.
Those will consider.
Yes, Lord.
Okay. Heard Miss M. Chaudhary, learned counsel for the appellant, who by means of this appeal referred under section 173 of the Motor Vehicles Act has put to challenge a judgment and ordered it is so and so, passed by so and so. Para. It is contended that two vehicles were involved and without taking into account the materials in the charge sheet,
Lord.
wherein the fault was attributed to the other vehicle, comma,
Yeah.
other vehicle, comma, the awarded amount has been apportioned at 50%, at the ratio 50-50, full stop. The learned counsel has also raised the issue of future prospects, which has been granted as 50% and has contended that the deceased, being a self-employed, comma, the future prospect would be 40%, full stop. Para. Admit, call for LCR,
Respond number 1.
P. Bora. Learned counsel appears and accepts notice on respond number 1.
One.
And SP Sharma. Respond number 4. You have already received copies? Let-
I'll serve.
Let extra copies of the memo of appeal along with the enclosures be served upon them. Full stop. Let steps be taken for service of notice upon the respond numbers
2,
2,
3, and 5.
3, and 5 by usual process. Steps within 2 days. Para. List after 6 weeks along with report on service. IA for what?
Stay of 50%.
Stay of 50% or 50%?
50% of the awarded amount.
And you have to
Not
pay
50%.
50% of the
It
50%.
become infectious load, otherwise that is the only grounds made.
Have they gone for a Baki Jai?
Yes, sir.
They have gone for Baki Jai. They have not gone for Baki Jai. They have already got 50%.
Yes, sir.
They'll not go for Baki Jai. Are you going for Baki Jai? Okay, will benefit you. 50% they'll again deposit. Heard, heard. Miss M. Chaudhary, learned counsel for the appellant. I go to the history metro. Huh? It will kill you, huh? Same. Actually, grounds to Kuba, grounds to a table. Last subject to deposit of 50% of the portion to be paid by the applicant appellant in the registry of this court.
Lordship, we hear the matter
Your what?
immediately because this is a matter, regarding stay, Lordship, will be difficult for
What difficult?
recovery.
What difficult? You are an insurance company. You are thinking about how many? 3,50,000.
25%.
You will have deposit 100%, madam, then. You are talking about 3,50,000, 50,000 by insurance company.
25% of 50%.
Will deposit 100%.
25%.
No, 100%. Already it's 50%. What is this, madam? 50%. Okay, last order to you.
Lordship, then, punishing of Indian.
We have just made an observation. As and when it will be deposited, they'll make a prayer.
Lordship.
Once they make a prayer, we'll give that observation. Okay, next.
Must oblige.
I respond.
May it please your lordship. Your lordship, in this appeal, our main ground is that the personal allowances and the income tax and professional tax ought to have been deducted from the gross monthly salary of the deceased while computing the loss of.
How much will be the net result, net deduction from the award?
The gross monthly salary was taken as 47,009. From there, this deduction would be
Now, how much difference will make in the award?
like 5,000 approximately.
In the award?
Yes. If the award make like
Have you worked out?
yes, your lordship, 30 lakh.
What is the
In
award
our
now?
ground, your lordship,
How much is the award now?
it's 1 crore 1,73,900. And there is a calculation in page number 6 of the memo.
What are your grounds that that there is no
The
deduction?
personal allowances and income tax and professional tax put to have deducted.
You are appearing for whom, Mr. Devnath?
I am appearing from the payment respondent number 1, 2, and 3. Wife of the deceased, daughter of the deceased.
What was the deceased doing?
Your lordship, he was a
Central
constable.
government employee, SSP, under SSP, he was a constable. Salary was 49,102. Call for the employer, for the tribunal. We have able his evidence, as per Home 60, that salary document. His salary was 49,102. And without the statement, he stated before the tribunal that in that employer disease has no income that time, that he has not to pay the income tax. So in appellant, they have stated in paragraph your lordship,
Now,
page number 3, that
who,
income tax should be deducted.
now who
Then I
were,
have a
who,
objection.
Mr. Devnath, who were the claimants?
Claimant, my lord, wife of the deceased, daughter of the deceased, and mother of the deceased. Daughter is a handicap.
No, so far as the dependency factor is concerned, there is no doubt, but on the death of the employee, what benefits are you giving, are you having?
Actually,
You not, don't have family pension?
I'm not getting any benefit. Also, no one am getting employment.
No, regarding the services rendered by your husband.
Yes.
On his death,
Uh,
while in service,
yes. As per different statement, it is 25
that's a lump sum.
lump. On that part, more than 20 lakhs taken away by, I should not pay for mother-in-law and others. So it's,
No, that's
they
a
are-
different matter.
what is that?
The SSB pays a lump sum.
Yes.
Not a family pension. Okay. Part 3 as Dr. Learned Counsel, who has preferred this appeal under section 173 of the Motor Vehicles Act against so and so, huh? It is submitted that while assessing the amount, comma, the gross salary has been taken and even no deductions have been made on the aspect of personal expenses towards expenses or personal expenses
Right.
of the deceased,
Person allowance.
allowances of the deceased. Full stop para. Admit. Call for the LCR. Three, Devnath, Learned Counsel for respond numbers
1, 2, and 3.
and has appeared for respond numbers 1, 2, and 3 and has accepted notice on behalf of them. You have copies?
Yes.
On behalf of the and submits that he has already been served with a copy of the memo of appeal. Full stop para. Let steps be taken for service of notice upon the respond numbers 4 and 5.
Your lordship, 4 is being represented by Mr. S. Das.
Yes, is there.
Yes,
Name
his
shown?
name is shown in the cause.
As does. Okay. None appears for the respond number 4. No. This respond number 4 has also entered appearance through counsel. Sri S. Das, who however is not present today, full stop. Let steps be taken for service of notice upon the remaining respond number 5 by usual process. Steps within 2 days. Para, list after 6 weeks along with service report. Are you for?
For stay of
How
the
mu-
order. Totally, we are ready to deposit 50%. Award.
Otherwise, it will not make much of a difference. 30 lakhs.
Can I pay? Hello, they, as per their calculation, if they are ready to pay 16,75,000. They may pay at this amount, but remaining part may be paid. As per their calculation,
50%.
I think they are not quitting on.
Where they have stated?
Page number
Page
6
six.
yellow slip,
Of?
in their appeal,
Page 6.
in their appeal. Page 6. They've stated the
Page
calculation.
6.
Page 6 of their appeal. Right, there. Difference between the
Page 6. Page 6, yes.
they have
Yes.
the difference they have shown 16,75,006.
Yes.
So that may be released and remaining part may be still.
Oh, let it be 50%. Oh, heard Sri S. Dutta, learned counsel for the appellant who by means of this application has paid for stay of the so and so, huh? Para, the connected appeal has been admitted today. Full stop. Sri and Debnath learned counsel is present for the respond numbers 1, 2, and 3. Full stop. The name of the counsel for the respond number 4 also appears in the cause list, who however has not appeared. Full stop. Para. After hearing, comma, the present application is allowed by directing that pending disposal of the appeal, comma, the impugned judgment and order dated so and so passed by the so and so shall remain suspended, subject to payment of 50% of the award in the registry of this court. Full stop. On such deposit, comma, the claimants may make a prayer for release of the same, what should be considered. Let them deposit first. You make a mention and come, will they allow it?
Plus development. May please your lordship, I am appearing on behalf of Mr. B. Piller. He is out of station for his treatment.
Yes. What is
But-
this?
Lordship, this appeal,
For announcement,
not for enhancement, your lordship, I am for the
owner.
owner, your lordship. Pay and recover was there. Direction of pay and recover
Hmm.
was there on the ground that fake license.
Hmm.
But Honorable Apex Court held that the burden is not upon the owner in regard of a fake license. And another ground is that
Okay, hard. Three, so learned counsel. Mr. Somiyar for, who appears on instruction of Sri B. Pushilal,
Lord,
learned counsel for the appellant, who has preferred this appeal under section 173 of the Motor Vehicles Act and against so and so, huh? It is submitted that the award, that the liability has been settled with the owner of the vehicle, in spite of there being a cover under the respond number 5 insurance company. Para, admit. Para, call for the LCR. Para, let steps be taken for service of notice upon the respondents by usual process. Steps within 2 days. List of the 6 along with report on service. Okay.
Lordship, in the meantime, respondent number 4 expired and it is represented by other, his name may be.
Okay. Steps lower agota kuba, huh? At this stage, notice the call for LC. At this stage, the learned counsel has submitted that the respondent number 4 has passed away in the meantime and is otherwise represented by the respondent numbers 1, 2, and 3, who are his sons and daughters. Sons and who are his legal heirs?
Legal.
Legal heirs. Accordingly, the name of the respondent number 4 is struck off. The steps. Huh?
This is appeal for enhancement compensation, Lord. Injury case, Lordship. And
Okay. Yes, we admit this.
Yes.
Hmm.
Yes, no, furnish them all.
Okay. We are on admission, he'll furnish. Heard. Free. A.R. Agarwala, learned counsel for the appellant, who has preferred this appeal under section 173. So, huh? By this instant appeal, the grievance of the appellant is with regard to the adequacy of the compensation granted. Full stop. Para. Admit. Para. Call for the LCR. Sri K.K. Bhattar, learned counsel accepts notice on behalf of respondent number 1. Let a memo of appeal along with the enclosures be served upon him. Full stop. Let steps be taken for service of notice upon the respondents 2 and 3. By usual process, steps within 2 days. List of the 6 along with service report. Same thing. Go ahead.
is also for enhancement compensation, Lordship. It is there. Thereby debited for income. 7,000.
For enhancement,
Yes, sir.
yeah, for the respondent number one,
Mr. Sum-
national insurance. Okay, hobo, huh? Kali judgment order bile hobo bla. D das Borman for respondent number one. For the sole respondent.
Sure.
Sole
For
respondent.
what?
Uh, 20 cut off, struck off. Sole respondent, huh? That's বাকি খিনি একে। খালি এটার steps lower দরকার নাই আৰু বলি। Reporter নালাগে সেইখিনি। Sole respondent রেখে লব। Call for record, so insist sole respondent। পিছৰ খিনি নাথাকিব একো, huh? Yes.
My deputy,
Name of MSC das Borman be reflected in the cause list.
okay.
বুঝি পেলা believe it করেন না set করব। 1-3, yes.
An appeal filed with the instruction based on quantum loss. The lordship is an injury case.
That case,
Injury case.
how much
Injury case lordship awarded 7,16,009.
grounds?
Ground is that lordship, the physical disablement was assessed at 45%. Planet member also assess the loss of earning capacity at 40%. That cannot be lost. These are not synonymous. This is one ground. And another ground is that admittedly he was 68 years at the time of accident. But multiplier accepted as 9, which ought to be 5. And thirdly, lordship 10,000 was accepted. It is not, there is no evidence. on
10,000 regarding?
monthly.
Okay.
So there was no evidence. These are the grounds.
Okay. Heard Ms. M. Chaudhary, Learned Counsel for the appellant who by means of this appeal preferred under section 173 of the Motor Vehicles Act has put to challenge a judgment in order issuance, huh? Silo, MSC so. Para, it is contended that amongst other grounds, comma, the impugned award has taken a wrong multiplier and also a wrong multiplier and the monthly income has been assumed without
Evidence.
any substantial materials on record, full stop. It is also contended that the loss of earning capacity has been sought to be equated with the percentage of disablement. Full stop. Para, admit, call for the LCR. Madam, you have for?
For the claimant respondent number 1. If my only prayer is that the 50% awarded upon
One, Joy, okay. Your name, madam?
RDIP.
RDIP. Miss RDIP, Learned Counsel, accepts appears and accepts notice on behalf of the respondent number 1. Full stop. Let steps be taken. And let an extra, have you been served with an extra copy?
Yes, sir.
Already served. Let steps be taken for the respondent numbers 2 and 3 by usual process. Steps within 2 days. 6 weeks, huh? For
2 and 3.
2 and 3. After 6 weeks, economic service report.
Then stays there.
Stay to a huh? It would application of I am Chaudhary, Learned Counsel for the appellant who by means of this application has prayed for stay of the judgment and order issuance, huh? Para. The appeal has been admitted today. Full stop. Para. After hearing and in the interest of justice, comma, the impugned judgment and order issuance passed by so and so shall remain suspended subject to payment of 50% of the awarded amount in the registry of this court. Full stop. On such deposit, comma, the claimant may make a prayer for its release, which would be considered.
Must apply.
Yes.
In an appeal against quantum, the judgment was ex parte against the This was a 21-year-old court.
Judgment, it was expert against you. You did not contest.
Not if, company had appointed an advocate in Dibrugarh. He failed to appear. Only some message was given that is an expert. And under advocate is appointed, he filed an application under Rule 9, Order 9, Rule 30. There was a delay application, he did not file along with it. But here it's a, the claimant's year was their income was 20,000.
Now this, there was a delay condonation. Here,
Yeah, yes.
it was condoned, delay has been condoned.
Delay in income.
Delay condoned, okay. Heard, Sri R. Goswami, learned counsel for the appellant who by means of this appeal preferred under section 173 of the Motor Vehicles Act has put to challenge a judgment and award it is so and so, passed by so and so, full stop. It is submitted that due to some miscommunication, comma, the claim could not be contested and accordingly the impugned judgment was passed ex parte qua the present appellant, full stop, para. Sri Goswami, the learned counsel, has submitted grounds,
Don't have file on quantum.
has submitted that the amount is on the higher side and there are no materials to support the same. Full stop, para. Admit
Because the entire amount before the. I propose the entire amount.
here.
Here.
He has also submitted that the amount in question has already been deposited in the registry of this court. Full stop, para. How much is the amount?
34,70,000.
That case.
Yes, sir.
Okay. Have you withdrawn any amount? Or you want to withdraw some amount?
My
Okay.
lord, because the main problem is that, my lord, they have deposited the entire amount minus this. But knows that the, my lord, the account of the registry is the current account. So the interest part, I'm not going to get. So I pray that, my lord, I may be allowed to withdraw the entire amount of the bond.
Not the
Because-
entire amount, you draw 50%.
Because my lord, then, my lord, because the insurance company will not pay the interest, my lord, let them give undertaking that if they fail in this appeal, they will pay.
Now,
interest.
how can be they settle double? They have not discharged, they have not failed to discharge. If the fault has to be attributed, it has to be attributed to the registry for having a current account.
My lord, the main problem is.
How do you settle them? That you have to pay the interest.
Because, my lord,
Whatever amount is due to them, will pay with interest.
because, my lord, they have deposited the amount voluntarily, my lord, before the admission of the appeal, my lord.
If tomorrow they are going to fail in this appeal, then your question will be considered, this one, not now.
Because, my lord,
Admit, ki koru?
because, my lord, the 1 year interest will be about full of fees.
We'll have something recorded here, huh? Admit us in the registry of this court. That's what admit. Call for the LCR. Mr. Gupta for
Respondent number 120.
AK Gupta, learned counsel, appears and accepts notice on behalf of respondent numbers
120.
1, 2, and 3. You have got copy?
Yes,
Have you?
I have
Okay.
copy of that.
Okay. Who submits that memo of the appeal, copy of the memo of appeal has already been served upon him. Para. Let steps be taken for service of notice upon the respondent numbers 4 and 5 by usual process, steps within 2 days. List after 6 weeks along with service report. State likha. Heard Sri R. Goswami, learned counsel for the applicant appellant, who by means of this application has prayed for stay of so and so, huh? Appeal jiri se ekhane judgment order passed by so and so. Sri Goswami has informed this court that the entire awarded amount has been deposited
Yes.
in the registry of this court. Full stop, para. Considering the above aspect, considering the above aspect, comma, this court directs that pending disposal of the appeal, comma, the impugned judgment and award of the learned so-and-so, past and so-and-so shall remain suspended, suspended, full stop. It is also directed that 50% of the, suspended, full stop, para. Sri Gupta makes a prayer for release of the amount in question, full stop. He has also contended that since the amount which has been deposited in the registry would be in a current account, which would not accrue any interest, comma, the aforesaid aspect should also be considered by this court, full stop, para. After hearing, comma, it is directed that 50% of the award be presently released to the claimants,
Claimant for one, so the tribunal has only.
to the respondent number one, on being duly identified by her counsel or his counsel.
Her.
Her counsel, full stop. The aspect of the interest, which according to the learned counsel would be a substantial one, would be considered at the appropriate stage. Highest stands disposed of.
Can this be, there be a direction at least to deposit this money in a fixed deposit so that both of us balance of the amount,
On the balance of, obviously.
balance amount of amount can be kept. There is a direct. And both of us are protected there.
We'll have to, it may not be an exceptional case. We'll have to just work out whether such a thing would be available.
In one such.
No, you are
filed
correct
by me,
that-
Lordship,
No, you are correct that you cannot be settled with the interest part after he had made the deposit. At the same time, they also should not suffer, because ultimately they will get the amount, if at all, after a substantial delay, and in the meantime, interest would accrue. We'll consider this aspect.
Alright.
Well, just a minute. Just a minute, please. Yes.
Appeal for enhancement with
Third, preempt of the learned counsel for the appellant who by means of this appeal referred under section 173 of the Motor Vehicles Act has prayed for enhancement of the award in the judgment and order dated so-and-so, passed by so-and-so. Full stop. Yes, what are your grounds?
Lordship, no amount has been awarded for loss of dependence.
Okay,
No amount has been.
that case,
That is,
it is submitted that the dependency factor has been overlooked. What's the para? Admit. Para, call for the LCR. Para, let steps be taken for service of notice upon the respondents by usual process. Steps within 2 days, para, list after 6 weeks, along with report on service. Oriental, is anybody appearing? Any counsel Oriental? No,
step by register to
no, usual process. Review. Doesn't matter.
It's a case where the price of it's not the order. By which the appeal, the entire appeal was dismissed for not bringing on record the legal errors of case where this person he died in an unfortunate. They was fight by father and mother of this. And during the penalty of the 50% was was withdrawn by the father. Since the wife had also expired midtime, mother of that expired. There was a statement by the father before the trial court tribunal that he had no son, daughter was. So, finding no alternate, the respondent counsel were asked to purchase the names of the still present. They failed. We had no option when that was called, find that not got the LR. But the appeal was, and we were asked also the amount back.
Till now not deposited.
My lord, 50% was deposited because of court, and that was withdrawn during the pendency of the appeal because the father claim was live at that. Well, we also tried at our end by.
No, review on what ground?
Well, the appeal was dismissed only on the ground that could not bring on the.
No, it was abated, therefore dismissed.
Was abated.
Therefore, you are left with no other option.
But,
Where is your setting aside abatement or application?
oh, that's not there.
Then where is the question of review? No,
Your
that,
Lordship.
for review, some error apparent. Now, this is a legal point taken, abatement. You can, you could have come for setting aside abatement.
This ticket type has arisen when
And this
had
you had
no
filed
option.
way back in the year 2018. You could have easily, whatever is this court had exercised appellate powers,
Well-
appellate court, same proceedings will lies. File an application for setting aside abatement. We'll consider whether we allow or not. That's a different part.
Well-
But to come for review, I don't think it's correct. Heard.
What
Three
I
RK
suggest- what I
Bhatt.
suggested matters. And we have exercised all our diligence to find out legal errors. Nor the respondent are in a position to provide us with the names or the legal errors of the second class also. There are not. No one is there in the family. So what I suggest is let me take instructions from the company and if only this amount, the 50% which is remaining, if your lordship permits us, we can deposit this on the report.
No.
And subsequently, my lord, we can.
No, that will be going beyond our jurisdiction.
My lord, I can.
Had it been a writ proceedings, equity jurisdiction, the matter would have been different.
I can.
Heard Sri R.K. Bhatra, learned counsel, for the applicant, for the review applicant who by means of this application has prayed for review of a judgment of an order dated 26/6/2013 passed by this court in MSC Appeal 198 of 2004. Also heard Ms. P. Bora.
A but
A. Bora, learned counsel for the
respondent number 2.
respondent
Owner
number
of
2.
the vehicle.
Respondent number 2, para. By the order dated 26/6/2013, this court had dismissed the appeal on the ground that though the respondent number 1 claimant had passed away on 7/8/2010, no application was filed for bringing the legal heirs of the said respondent on record. And full stop. This court had accordingly held that the appeal against the respondent number 1 claimant stood abated and consequently The appeal was dismissed. Full stop. Para, for ready reference, comma. The order dated
I
26/6.
beg your pardon, Lordship, for the interruption. I'm appearing for the payment.
Oh, one. For ready reference, the order dated 26/6/2013, for which review is sought for, is extracted herein below. Full stop. Para. It could code. Sri Bhatra, comma, the learned counsel has submitted that in spite of best efforts, comma, the legal heirs of the claimant could not be traced out, and therefore no steps could be taken. Full stop. Para. The aforesaid contention would not come within the limited scope of exercising powers of review, which has to be for correction of an error apparent on the face of it. Full stop. The para. The Honorable Supreme Court in the case of Madhusudan, so and so. Para. In the instant case, comma, in the instant petition, comma, the order sought to be reviewed, dated 26/6/2013, is on the point of abatement of the appeal due to not taking steps to bring the legal heirs of the claimant respondent number 1, full stop. There is no dispute to the fact recorded that the aforesaid claimant respondent number 1 had passed away on 7/8/2010, and the order was passed almost after 3 years on 26/6/2013, full stop. The applicant has admittedly not filed any application for setting aside abatement in the procedure prescribed, full stop. Para. In the considered view of this court, comma, the present is not a fit case for entertaining, full stop. Accordingly, the petition is dismissed.
Right. Look,
Yes, Mrs. Smith,
the confirmation of delay.
delay condemnation. Notice is served.
One of the process for the name and appearing.
Names appearing. Who were there? R. Sharma, SD Saikia, PM Kolita. How many days?
800
So, the explanation.
One of explanation.
You are the corporation.
One
You don't say that you did not have knowledge.
we have the knowledge, but after receiving of spread copy, then approval was sought for typing the bit. And during the communication gap, approval was granted. And then again, after receiving of the approval, some again, spread copies and depositions were required. 2/4, paragraph 4.
Mr. Corporation, your conduct is not good. You are the corporation. If you take 800 days to get an approval, what bona fide did you have in preferring this appeal?
Approval was granted for the 2016 only. After that, for the council, but then council sought some instructions for some depositions of the record.
What is
Then
the judgment?
Such-
It is not covered.
Hello?
Judgment is not covered.
No, my lord, there are some subsequent questions of law involved, whether, my lord,
No, the judgment has said that it was not covered under the act,
my lord,
or what?
my lord,
And therefore they are not liable to pay
my lord, they have no liability.
the contribution. Okay. I heard Sri M. Smith's learned counsel for the petitioners who by means of this petition filed under section 5 of the Limitation Act has prayed for condemnation of delay of 801 days in preferring the connected appeal. Full stop. The appeal has been preferred against a judgment and order dated
24/8/2000.
24/8/2016, passed by the learned ESI Court,
High Court.
huh?
Employees
EI Court, Employees Insurance Court, EI Court, in
ESI case number.
ESI case number
4/2014.
4/2014. Full stop para. Notices were issued on 1/2/2019, whereafter the respondents had entered appearance. Full stop. However, comma, no one has appeared today in spite of, no counsel has appeared today in spite of names reflected in the cause list. Full stop para. The learned counsel for the petitioners has, and by referring to the averments made in paragraphs
3 and 4.
3 and 4, has submitted that because of some office formalities and also the ailment of the conducting counsel, comma, the delay has occasioned and there was no willful or deliberate laches on the part of the petitioners. Full stop para. Considering the grounds, the aforesaid grounds have been considered. Full stop. An adjudication of an application concerning condonation of delay has to be done by taking a pragmatic and justice-oriented approach, wherein substantial justice is to be preferred over technicalities. Full stop. At the same time, comma, the aspect that by operation of the law of limitation, a right accrues, a substantial right accrues to the other party cannot be wholly ignored. Full stop para. Considering the above, comma, this court is of the opinion that the delay may be condoned, which however would be subject to certain conditions. Full stop para. The instead application accordingly stands allowed, and the delay in preferring, and the delay of 801 days in preferring the appeal against the judgment and order dated 24/8/2016 against by the learned Employees Insurance Court is condoned, subject to payment of rupees. How much? Rupees 10,000 in favor of the Guwahati High Court Bar, Guwahati High Court Advocates Welfare Advocates Welfare Fund. In the appeal, you write the connected application, connected IA Civil 322/2019 for condonation of delay has been allowed today, subject to payment of cost. Full stop. On receipt of the proof of such deposit, comma, the appeal is to be registered and listed for admission. Welfare Association to Welfare Fund to syllabus.
Support
Just a minute, please. There are two respondents, madam. One, you have appeared,
One appeal.
and two,
The page.
when did you take steps?
Notebook.
29/4. 29/5, 29/6.
The third appellant is in favor of respondent number 1. Two is
In view of the office note dated 22/5/2024, whereby which reflects that neither unserved notice nor ready card upon the respondent number 2 has been received back, comma, the matter may be listed before the learned Lozima court to pass appropriate orders on deemed service. Full stop. Sri Hassan,
FS.
F.A. Hassan,
Yes.
learned counsel has entered appearance for the respondent number 1.
Please, notices have been duly served on the respondent. The this also reflected the name of the counsels for the respondent.
Mr. Adhyapak for 1.
Yes, not 1.
And 6 and 7, S.J. P. Deka, who are they? 6, 1 has appeared. 6 and 7, all have appeared.
Yes, but notices are complete.
This in the CRP.
Lots of.
We can hear this matter.
Lots of. The issue is lots of,
No, not today.
yes.
Immediately on the reopening, we'll hear the matter.
Yes,
Since they-
this matter.
Yes, I heard Sri A. Sharma, learned counsel for the petitioners. Full stop. Also heard Sri S. and Adhyapak, learned counsel for respondent number 1. Full stop. Cause this reflects that the respondent number 6 and 7 have also entered appearance through counsel. Full stop para. The case was pending on the aspect of service upon the aforesaid respondents.
Got it.
Full stop. Considering that the said respondents have been served and have also appeared, comma, list this case for admission, admission hearing on, yes. Can we have it on 22nd of July?
Lots of. Because it is
20
necessary,
2020 matter. We'll have it on 17th of July.
because my lord, why this is necessary, because on the previous occasion,
We have seen that.
yes, my lord,
17th.
stay has been vacated.
17th of July. You did not take steps, therefore the stay has been
Lordship,
vacated.
that is very correct, but then again, my lord, if this could proceed, which is,
That is why you are fixing immediately on the video.
yes,
17th.
applies, lord.
Mr. Aludra?
Repeated. ISW number 49 of 24. Declared
Which one? 49.
40.
Who has passed away?
The sole
You are representing the sole respondent.
Yes.
Now will you represent the legal heirs?
legal error.
You will be representing.
After filing color number 14.
Okay, but you have the instructions to appear.
Yes, sir.
Okay, then
On
let him file.
transported I was not available. in
Doesn't matter. Okay. V. Rai.
Yes.
Heard Ms. V. Rai, learned counsel for the applicant, who by means of this application is seeking substitution of the legal heirs of the sole respondent. First para. Sri L. Talukdar, learned counsel, who was appearing for the sole respondent, has submitted that he would be appearing on behalf of the substituted respondents and would file the wakalatnama shortly. Full stop para. I accordingly stands allowed, and the sole respondent be substituted by his legal heirs. Where have you named them, Madam?
Paragraph
Paragraph?
2,
Page?
page 4.
Page 4. The respondent was Mohit Chandra Talukdar.
Mohichandra Lawkar, wife,
Lawkor.
son and daughter.
Okay, okay. এইটো পেজ 4 গোটেই কেইটা নাম দি দিবা হা ইয়াৰে 4 5 লম্বা আছে কিন্তু এইটো হা I accordingly stands allowed. Full stop in the main CRPO, right? In view of the IA 49 of 2024 for substitution of the sole respondent has been allowed today. That is so and so. Full stop. The petitioner, the learned counsel for the petitioner, Ms. V. Rai, is accordingly required to file amended memo of cause title incorporating the names of the legal heirs of the original respondent number 1 in the registry within a period of a week from today.
Yes.
Week from today.
CP applied.
Full stop. In the meantime, Mr. L. Talukdar, learned counsel, may file wakalatnama on behalf of the substituted respondents.
It is a dot. Service has already been complete. Healthcare is also it may fix.
This
In
was
I-
admitted already.
In
Yes,
item 21, your lot. 21, I have filed one case here
This
For
case
if-
for
for impeding the legal heirs of the.
this case number
It's case number 151.
who has passed away? Who has passed away?
Passed away one Somera Lee, your lordship. And here in the applicant number 1, he is the mother of the deceased, and 2 is the wife, 3, 4, 5, 6.
No,
They are
who has filed this?
My lord, yeah, that is
company.
You have filed this?
Yes.
No, IA has filed by filed by
I have filed by us here.
respond.
I have filed.
whose appeal is this?
Appeal is our.
Then why do you file an application?
In the appeal, your lord, only the father of the deceased was freed. But the wife, son, they have not been implicated.
Okay, it's not because of substitution.
Okay.
IA is for what? Under what provision?
For impleading of the
Oh,
party.
impediment simpliciter, 110, okay.
Yes.
Okay. Yes, we'll allow this. Okay. We thought it was for substitution. Oh. Your AM Khan?
Yes.
I heard Sri AM Khan, learned counsel for the applicants, who by means of this application filed under Order 1 Rule 10 of the Civil Procedure Code has prayed for implementing them as respondent numbers 3, 4, 5, 6, and 7 in the connected MFA 17 of 2023. In the original case, you were there.
No. The original case also.
Why didn't you apply in the original case for implement?
Because the place 8, your lordship kindly see the award. This is the award here.
Page 8.
Yes.
Yes, 8 of the
Place 8
IA
of
of
the
your
appeal,
IA.
your lordship.
Of your
Appeal,
IA.
Appeal.
Okay, what is there?
This is the award passed by the Workman Commission, your lord. In herein, no one of the family member of the have been implicated.
So what did you do?
We came to learn only after receiving the notice from this served by this honorable court, your lord.
Upon whom?
Upon the applicant, respondent number 2.
Respondent number 2 was the claimant.
No, respondent number 1.
1 was the claimant.
Initially, as I have been got instruction, your lordship, initially this case was taken as sumomoto case by the commissioner. And accordingly, no one of the family member of the
Now,
deceased was
will you
implicated.
also appear for the rest of the respondents?
Herein,
Mr. Khan, you see, you have, by this application, you are trying to get inside the case. Now, is there any conflict of interest between the newly implemented respondent and the original claimant?
original claimant, no one was implicated, your lord.
Then who is this in the appeal? Surman Ali.
Surman Ali, he is the father of the deceased.
Then,
Only the father was implicated, but from the,
no, are you also appearing for Surman Ali?
yes,
You will be appearing?
Yes.
Okay, then there is no problem. If there is no conflict of interest, then there will be a proper, okay. Then if you have a conflict of interest, then the matter will be different. Ki korla, sir?
it was
Full stop. Full stop. It is contended that though the present petitioners are the legal heirs of
Omer Ali.
the deceased,
Yes. Yes.
They were not implicated as parties before the commission. Full stop. The Learned Council also submits that only on receipt of notice by the respondent number 1 that they could learn about the present appeal. Full stop, para. Considering, also heard Miss S. Musahari, Learned Council, for the opposite party appellant, who does not raise any serious objection to the aforesaid prayer. Full stop, para. Considering that the petitioners are the legal heirs of the deceased employee, deceased, comma, the instant application is allowed by directing implement of the petitioners as respondent numbers 3, 4, 5, 6, and 7 in the connected MFA number 17 of 2023. Where I accordingly stand disposed of. Madam, you filed an amended cost title in the appeal. In the appeal, you write. The I-1512 of 2023 for implement of parties has been allowed. Full stop. Allowed today. That is so and so. Ms. S. Musahari, Learned Counsel for the appellant. is accordingly required to file an amended cost title incorporating the names of the newly implemented respondents. Full stop, such, within a period of 1 week, 1 week, can you do it? 1 week from today.
Please, the Lordship, as per last office note date, last office note, it shows that service upon respondent for 4 to 7 is awaited, Lord.
Chakraborty, for whom?
My lord, I'm for respondent one and, my lord, my concern, may I submit first, kindly come to page 102. There was performance, but not, perhaps, service not required for this. In fact, my lord, respondent number 3, which was also a performer party in the suit, they have made them a main party here. So, my lord, my humble submission, my lord, is that.
Did you take steps?
Lordship.
Steps were taken. By registered post with AD?
Yes.
When was it taken? It was taken almost a year back.
This is the same, my lord, as that of the suit.
Who are they?
They are the legal heirs of, my lord, appellant number 1. I'm sorry, my lord, the sons and daughters of appellant number 1. Appellant number 2, and the other performer parties are siblings,
And you are for?
except performer, respondent number 3, my lord, who actually was supposed to be a performer party, but they made a main party. She is the sister of respondent number 2,
Now, can you, are you in touch with the other respondents?
except respondent number 3, the others I have.
3, can you, have you, is the respondent number 3 aware of this appeal?
Yeah, I know, she is my sister.
So she is not appearing.
Yes, she has no interest in the, for as I know. And they have pleaded, my lord, at least, my lord, in their suit, in the pleadings, 102, my lord, para 19. They have specifically pleaded, they have got no claim against the performer party.
Where, Sarah?
Para, page 102, my lord, of the suit. May I read, my lord?
Yes.
Para 19. That the 2 daughters of Paramananda Borua, Vice Dola Soikia and Nirmala Borua are residing at their matrimonial houses at Guwahati and Surat respective. Partha Sarathi Borua has been residing in Guwahati in course of his business, in spite of having intention to join as plaintiffs, but for inconvenience to attend the court urgently, they could not participate and sign the plaint as plaintiff, for which they are made as performer defendants, claiming no relief against them. Further, the performer defendant number 3, that is my sister, my lord, respondent number 3, has not shown interest to go for litigation for which it should have seen, my lord. He is also made as a performer defendant. But if any of
Did
the
they appear in the suit?
Yes, suit.
No, did they appear the performer
No, they
respondents?
didn't appear. So what is the requirement? I don't understand. Here is the, so,
Now, 3 has been transposed into a principal respondent here
yes.
in the appeal.
Disposed of.
No, in the appeal. In this appeal.
Yes.
Respondent number 3 is a principal respondent or performer respondent.
So they have made a principal respondent.
Why? You are for Harinarayan.
I am from Harinarayan and Madhurya.
Mr. Bora, why have you transposed the respondent number 3 as main respondent here since she was a
So Bora is late, Lordship, and taken up.
who will consider this after the vacation? Will record some of your
Alright.
submission. Office notes indicate that neither ID card nor unserved notice has been received back so far as the responsibles 3 to 7 are concerned. Full stop para. Sri R. Chakraborty, learned counsel for the responsibles 1 and 2 by drawing the attention of this court to the pleadings made in paragraph 19 of the plaint has submitted that all the aforesaid respondents were made pro forma defendants in the suit and they did not even contest the suit, full stop. He accordingly submits that there would be no, that interest of justice would require striking of their names as delay in pendency of this appeal is causing prejudice. Full stop para. Sri, your HK Bora,
You go, sir.
you,
Behalf of.
You name?
go. You go.
you go, Sri, you go, Mr. Bora. You are there. They are pro forma.
But they are the, because my lord, Makhani Borwa, they are the brother and sister of
No,
Makhani.
but in the suit itself, in the plaint, you have said that you are making them pro forma because you do not have any claim against them.
Yes, my lord.
And 3 was also a pro forma
Yes, my lord,
defendant.
yes.
But 3 here you had made a principal respondent. Why? On your own, can you change the position in the appeal? You
No,
cannot.
my lord.
You come to paragraph 19 of the of this paper book 102.
Yes, my lord. Yes, my-
102.
yes, my lord.
Please read. So they were pro forma defendants in the suit. They have not contested the suit. We'll strike off their names.
Yes, my lord.
Okay. All of change over. Key listen. Over. This is full sapera. 3.
Suit is pending. It is against the temporary injunction.
Oh, no. Delay in causing prejudice? Yeah. Prejudice? Yeah. Delay in pendants, delay in this. Yes. Okay. Delay in disposal of this appeal. Same thing. Para. Sri DP Bora, learned counsel for the whom? Respond numbers? For the appellant. For the appellant. Does not seriously dispute the aforesaid factual proposition. Full stop. Para. Considering the above, comma, the names of the respond number 3 and the pro forma respond numbers 4 to 7 are struck off from the array of parties in the appeal. Full stop. Para. Is this appeal admitted already? Why not?
So that
Appeal has to be admitted.
perfect.
Admitted for hearing. It is an appeal. It has to be admitted.
Yes, my lord.
31-7.
Yes.
List for consideration. When?
When?
On 19th of July. What is the appeal about?
So they have claimed title to adverse position to by instance.
My lord,
Now
quick
they
question
have
is
filed an
adverse
injunction,
possession.
temporary injunction.
That was
Already we have-
rejected. Yes.
Except the person has been handed
Basic
over.
question is adverse possession and they
No,
forcibly.
we are not on the subject matter. Here we are on the subject matter of this appeal. Injunction.
Yes.
Yes, my lord.
Injunction was rejected.
Yes, my lord.
Rejected.
This is the first appellate court
Yes, my lord.
as per pecuniary
Yes,
jurisdiction.
madam.
Okay.
So there is a interim order by the honorable court to maintain its
That
status.
was vacated by another coordinate bench.
No, my lord.
Vacated.
No, my lord.
31-7 order, my lord. That was.
Your
that was-
lordship may peruse the interim order because it has been stated that interim order is in force till the disposal of the appeal.
Subsequently by another bench been vacated. That order has been vacated.
Where? Page?
No, not vacated. The subsequent order says that interim order is not extended. But my lord, there is no any question of extension of the interim order by lord.
But is there a specific order of not being extended?
Yes, sir.
But first order
In the
says that
appeal.
the interim order is till the disposal of the appeal, my lord.
Where is the interim order?
31-7.
Very
First order.
concerned. Oh,
In the main appeal, my lord.
not in the IA.
No, it was not passed in IM.
In
It
the
was passed in the.
appeal, my
It is why perhaps it was not extended.
Okay. Let us not go into these controversies.
Yes, my lord. Obliged, my lord.
Basis the lordship. Your lordship, in this case, respondent number 1 and 2 has already entered appearance. But your lordship, as regards respondent number 3, your lordship, office note dated 29/5/23 states that addressee could not be traced. Respondent number
Mr.
4 has been
Burra
served.
for 1 and 2.
Yes, my lord. My lord, may I bring your
Just a
lordship
minute, just a
attention
minute,
to
has
the-
When it comes to answer notice and recipient posted notice now. Father's name is unclear.
Respondent number 3 is the owner of the vehicle, your lordship. And we are challenging the quantum
Four,
of-
four has been served.
Yes,
also.
your lordship, 4 has been served.
Only 3 is left out.
Yes, your
3 is
lordship,
the owner.
owner, and we are
And you are for the
challenging the
insurance
quantum.
company.
My lord, I am for the claimant.
Oh, okay. You are the insurance company. Okay.
My lord, kindly look at the IA that they had filed. IA number 2284 of 22.
Disposed of.
Yes.
That was
Yes.
the
So there was the order dated 31/3/2023, my lord, to kindly peruse,
Yes.
wherein they had submitted that since the insurance was not in dispute, therefore the owner was not a necessary party, and they requested that he be struck off from the area of parties just allowed by this court. Therefore, he does not have to be served anymore. He should have been removed from the area of
Lordship,
parties.
I am making the same prayer that respondent number
They
3
cannot
is
go back on
not
that
a
prayer, my lord.
necessary party.
Okay,
here,
no,
so
they are
he
not
may be
going
struck
back.
off.
The IA has already been allowed.
They are not going back. They are also praying for striking off.
Oh, okay. Yes.
You are on the same boat, brothers and sisters,
We'll do it together, man.
not brothers.
Struck off, your lordship.
Okay. M say kya?
Report.
P?
Report.
Okay. Learned counsel. You are not there on record. Doesn't matter. Learned counsel, by referring to the office note dated 29/5/2023 has submitted that while the respondent numbers 1 and 2 has already entered appearance and the respondent number 4 has also been served, comma, the respondent number 3 has not been able to be served, full stop. She also points out that in the connected petition, in connected IA Civil 2284 of 2022 for condemnation of delay, comma, the respondent number 3's name, 3 iske बाद apostrophe दीजिए, was struck off, full stop, para. Also heard Sri A. Burra, learned counsel for respondent numbers 1 and 2. Para. In view of the above, comma, the name of the respondent number 3 is struck off from the area of parties. Full stop. Appeal has been admitted.
Yes, your lordship, appeal has been,
Record the issue.
as there has been received, your
Okay.
lordship.
Since LCR has been received,
Yes.
comma, the appeal may be listed for hearing in its turn.
Perhaps the date may be
22 matter, they are old matters, otherwise you'd have fixed the date.
Object.
okay.
Yes, your lordship.
Yes.
It's right up.
Hmm?
We are trying to take the. We are trying to take the.
File is missing.
No, lord. We need some time.
Press?
Step.
Press steps. Upon whom? Sole respondent. They are already appearing, I think. Here for the sole respondent.
Yes, sir. My lord, the present appeal should be dismissed at the outset.
Madam, you need not take steps. You need not take fresh steps. He is already there.
Yes.
Yes.
My lord, the present appeal should be dismissed at the outset on the ground of delay in filing the application under section 53 of the Railway Claims Tribunal Act. My lord, in the case of Union of India versus Jasiruddin Talukdar, it's a 2010 judgment passed by the Honorable Guwahati High Court. In the state judgment, the High Court has reiterated that Railways Act is a special statute and delay cannot be condoned by the Honorable Guwahati High Court. And further, my lord, in the
You
case
filed your objection in the IA.
yes,
You
my
filed your objection. You filed your objection in the IA.
no, my lord, the objection has not been filed.
You file, we will consider your objection.
Sure,
That
my lord.
section, if you are contending that section 5 is not applicable for
Yes.
condemnation of delay, you file an objection.
Yes, my lord, Honorable Guwahati High Court has reiterated
No, no,
in Katina of
you,
Judgment.
you file your objection.
Sure,
What is your name?
My lord, Advocate Divyansh
Divyans
Rathi.
Rathi. Okay. Madam, your Sharma, Anand Sharma. Heard Miss Anand Sharma, learned counsel for the applicant. Full stop. Para. Sri D. Rathi has entered appearance for the sole respondent and has submitted that the application under section 5 of the Limitation Act would not be applicable. Full stop. The learned counsel accordingly prays for and is granted 4 weeks time to file objection.
My lord, if you can provide a date after the petition.
Okay, well, provided it, how soon can you file?
My lord, as soon as per date.
Now, we'll
We'll
give a
file it
date
by
in 4
tomorrow
weeks.
itself.
You tell us, list on. What's the date? 20, not 20, also 24th, okay. We'll have it on 29th of July, okay?
29th.
Right.
Much obliged.
File your objection.
Sure.
What is that decision?
Sure. My lord,
The
I
counter
brought,
tie up your code buttons. Don't come like this. Tie up your buttons. Code button. Down, down. Code. Don't open it like this. Yes.
my lord, I have brought 7 judgments passed by the.
Give us one judgment.
That particular, okay.
My lord, in paragraph 31, second last paragraph.
Yes. Paragraph 31.
31. Para 27 is also relevant.
Hmm.
The correction is to para
Yes. 27.
but also it is pretty much mentioned in one of the.
Just a minute.
Sure.
Wait. Yes, what is your immediate reaction, Mr. Gogoi?
Lordship, that issue was also pending before Honorable Apex Court, Lordship, and our High Court in similar matters, Lordship, they have adjourned the matter till the outcome of the Supreme Court. I will place that judgment. Otherwise, also, other High Court, there's full bench judgment also there. Lordship. Contrary view was taken, Lordship.
Does the statute has any provision for condemnation of delay in an appeal in the Railways Act?
Railways Act, other provision is there.
No, no. Are there any provisions
It is
like the
there.
MACT?
Eh.
It also has the proviso for
Lordship.
condemnation of delay.
Lordship.
You read along with section 5, that's a different
Lordship.
matter. In the Railways Act, is
Railways
there-
Act, that is specifically not there. Otherwise, Lordship, there is a provision for condemnation of delay.
in the Railways Act,
Railways Act,
which provision? 29.
29.
What is the language?
It is, today I am not seeing the book, Lord. And Lordship, otherwise also that particular issue, Lord. The other High Courts have taken contrary view, Lordship.
No,
It
can
is
you
a
equate
suspend-
this with section 34 of the Arbitration Act?
Okay.
Is it a provision similar with section 34 of the Arbitration Act?
In that part, Lordship, view is, various High Court view is defined.
Okay,
View
we'll
is defined.
consider this.
Even our High Court view is also, Lordship, two of the cases view is defined. I will press this up.
My lord, just, I would just, put.
We'll
your-
consider this on the appropriate time. Okay, you come prepared.
my lord.
File your objection and come prepared.
Oblige, Lord.
Services. Office number 36.
Mr. Deori, you are appearing.
Yes. And
What has happened to the 710 petition?
That instruction,
Okay. Yes,
it's pending you. This shared,
yes, tell us when we have this matter.
yeah, this matter along with my lord, yard number 67 of
That is regarding what?
this and then,
It is here in this court.
yes,
That was allowed.
it was not about this pending. Have filed a yard against it.
No, 710 was disposed of.
But it was-
Then the challenge is presently in the High Court in CRP 267.
Yes.
267.
267
Okay. We'll have both the matters.
together.
Okay. It is submitted that there is a connected CRP IU 267 of 2023. Full stop. List along with, list both the cases together after the vacation, immediately after the vacation, summer vacation.
my lord.
Okay, Lordship.
Yes, yes.
Lordship, I beg to withdraw this matter. The matter has become infectious.
Okay. B. Fukan,
Yes, Chief.
other side. Heard Sri B. Fukan, learned counsel for the petitioners who has submitted on instructions that by efflux of time, comma, the matter has become infructuous, full stop para. The petition is accordingly dismissed as infructuous.
Me, please, sir. This case, respondent number 124 has already appeared. Okay. Respondent number 5 has, as per office note dated 26 for 2020 service to the respondent number 5 has returned with postal remark as addressee move. Lordship. So we may be allowed to take fresh step by publication of notice leading.
Upon 5,
5.
I am for respondent number 1.
1 to 4. There are only 5 respondents.
Yes.
1 to 4 already madam is appearing.
Yes.
5 you want to take paper publication, okay. You have taken instructions on this?
Yes.
Okay. NM Datta,
Yes,
Howard 3 NM Datta, Learned Counsel for the appellant, whereas Ms. P. Bhattacharya, Learned Counsel appears for the respondent numbers 1, 2, 4, TO2, 4. Para. As the service upon the respondent number 5 is not complete, comma, Sri Datta, the Learned Counsel, has submitted that such service may be allowed to be effected by paper publications, full stop para. On consideration, comma, let the respondent number 5 be served by paper publication, which is to be done in one issue of the Assam Tribune and another issue of the Doinik Asom. Full stop. The notices are to be vetted by the registry of this court. Full stop. Let the next date be fixed on first of August 2024, prior to which date, comma, the Learned Counsel is required to file and to put on record the issues of the concerned newspaper. No, issues no. The concerned issues of the aforesaid newspapers by way of an affidavit.
Please, your lordship.
Yes,
I have filed for condonation of delay, lordship.
no problem. How many days?
4 days.
4 days, okay. J. Kolita,
Yes, lordship.
I heard Ms. J. Kolita, Learned Counsel for the applicant who by means of this application has prayed for condonation of delay. You have written 7 days.
4 days.
Lordship, here it says
7 days. Delay of 7 days. You have also written 7 days and officers also calculated 7 days. You have corrected it in our copy, 7 days.
yes, lordship.
7 days, full stop. It is submitted that the delay is wholly unintentional. And there is no negligence or laches, full stop, para. Sri A.K. Datta, Learned Counsel for Learned CGC appearing for the sole respondent, does not seriously object to the aforesaid prayer for condonation of delay, full stop, para. Considering the causes shown and also the aspect that the delay is only of 7 days, comma, the same is condoned. Full stop. I accordingly stands allowed. In the main right, the connected IS Civil 3228 of 2023 for condonation of delay has been allowed today. That is so and so. Appeal to be registered. Appeal is directed to be registered and listed for admission after the vacation. I to dispose of कर दें. 30. Madam, your fault.
I is for condonation of delay, madam. Of 193 days. Here we have taken steps, madam. We have
Is this your matter, Madam Chaudhary?
My
Your
lord,
name
I
is
have,
not there?
I have signed the wakalatnama after filing of the appeal, my lord.
Okay.
My signature is
Okay,
there.
okay, doesn't matter. Now, at times there are mistakes, so Your signature is also unfortunately perhaps not there. Let me check. Let me check. Okay. Madam, signature আছে নি হেৰিত বেলেগ ফাইল আছে নেকি আৰু SB চৌধুৰী আছে নি বেলেগ নে Okay. Heard Miss SB Chaudhary, learned counsel for the applicant. Yes, what do you say?
And for one lordship, yes,
Yes. How many days, madam?
193 days. Condone,
Okay, SB Chaudhary, who has filed this application praying for condonation of delay of 193 days in preferring the connected appeal against the judgment and order dated 6/1/2023 passed by so-and-so in so-and-so. You are praying for enhancement.
yes,
Enhancement. The applicant is the claimant who in the appeal has prayed for enhancement of the award. Full stop para. The learned counsel, by referring to the averments made in paragraphs 3 and 4 of the application, has submitted that the delay in preferring the appeal is not intentional and had occasioned for certain cogent reasons. Full stop. Para. Ms. M. Chaudhary, the learned counsel for the insurance company, has however submitted that the delay is substantial of 193 days and has not been properly explained. Full stop. Para. This court, on perusal of the averments, has noticed that certain reasons have been cited that the advocate concerned had to go for medical treatment outside the state, and in the said process, the delay has occurred. Advocate goes for a treatment, case is yet to be filed. How is it connected?
my lord, the appellant, my lord, he has no knowledge, he handed over the, my lord.
Where have you
case to the-
stated?
My lord, regarding the, I have also annexed the medical documents, my lord.
No. क्या बोला? Had to go outside the state for medical treatment, and thereafter a different advocate had to be engaged. Full stop. Para. Considering the above, comma, the delay in preferring the appeal is condoned, and the I accordingly stands allowed. Or appeal में लिख दीजिए, हाँ? The IA so and so for condonation of delay has been allowed today. Appeal to be registered and listed for admission after the vacation.
If, name may be Sony, or name may be.
The names of Ms. M. Chaudhary be reflected in the cause list for as counseled for the respond number 1.
Must apply.
Okay. এসি আছে না আসলে Oh, dear.
Every. Lordship may schedule the office note dated 12/6. 12 June, my lord.
Huh? 30?
Office note 12.
Mr. No, it will be submitted.
Pardon.
Oh.
I'm sorry.
No, okay, we'll have this after.
yes.
30. Okay.
Office note dated 12/6/2020.
Yes.
As part of this office note, lordship, the notice has been received by the brother of the respondent. It is reflected there.
What about the dusty service? What did
Justice
you,
service, my lord, I have filed an affidavit.
what did you state in your affidavit?
I stated that the petitioner tried to serve the justice service.
He had
but,
refused. He had
yes,
refused.
Yes,
Okay.
through unit. As my lord, the matter is for the consideration of the interim order also.
You are seeking transfer.
Yes,
Transfer.
transfer of the petition, my lord. The husband and wife, husband filed their divorce petition there. Before the learned principal, just family court not party, my lord, whereas both of them are frustrated.
Okay, we'll do one thing today. Today we'll hold the service to be complete.
Yes, my.
And today, same day, also considering that prayer may not be proper.
Yes, yes. So, my lord,
Uh,
that may be.
you are Deborah,
Yes, my.
Hart Street Deborah Learned Counsel for the petitioner. Full stop, para. Why the order dated 23/2024, comma, notice was issued to the sole respondent in this application filed under section 24 of the Code of Civil Procedure. And in terms of the same, comma, steps were taken by the three modes of registered post with AD, comma, usual process and dusty. Full stop. Office note dated 12/6/2024 has reflected that the notice was received by the brother. Full stop. The Learned Counsel has also referred to the affidavit filed on 19/4/2024 in connection with the dusty service. Full stop. Para. Upon consideration of all the aforesaid materials, comma, service upon the respondent is deemed to be complete. Full stop. Para. List for consideration on, we'll have it on
Yes.
17th of July.
Yes, my.
Full stop. On the said date, comma, in terms of the earlier order, comma, the Learned Counsel for the petitioner would be at liberty to press for interim order.
Yes. March.
Yes, what is this?
Lordship, I for delay confirmation 210.
Mr. Boissa for
I'm for opposite part.
filed objection or will you file?
Yep.
No objection. How much is the delay?
Lordship 210.
What is the appeal about? MSC appeal?
MSC appeal. Lordship, appeal is for enhancement of the appeal.
You are for the Bajaj Alliance?
Yes.
Okay, okay. Heard. M. Jaman,
Lord.
Learned Counsel for the applicant who by means of this application has prayed for, an application filed under section 5 of the Limitation Act has prayed for condonation of delay in preferring the connected appeal against, now with regard to, with regard to the judgment and award dated so and so passed by so and so in so and so. The appeal is for enhancement of the award. Full stop. Para. The Learned Counsel, comma, by referring to the averments made in paragraphs 3 and 4 of this application has submitted that there were sufficient reasons for not being able to file the appeal within the time prescribed by limitation. Full stop. It is submitted that injury case
Dr. B.
that the appellant claimant was yet to fully recover, and therefore the delay has occasioned. Full stop para. Sri R. Bushra, learned counsel for the opposite party, however, submits that the reasons may not be sufficient. Full stop para. Upon considering the rival submissions and taking into account the settled position of law that a pragmatic and justice-oriented approach is required while adjudicating an application under Section 5 of the Limitation Act, the delay of 210 days in preferring the connected appeal is condoned. Full stop. I accordingly stands allowed. And in the appeal, লিখি দিবা হা এটু appeal to be registered after vacation.
Made by the socket as the on earlier occasion the delay was
Pilot, it must have come from
Now, how does it make any difference whether it's in the hearing column or motion column, or we take it as motion? Yes, what is it?
I thought our prayer is that to we have filed this appeal for
This is not an appeal, madam. What is this?
petition has been filed for eviction and recovery of the area rent for us.
You're the landlord. Suit for ejectment
Right.
and recovery of
Area rent.
area rent. Then suit was decreed or not?
Find out in the lower court our appeal is and the
Not
suit was
appeal, the initial suit. Your
also
suit was also dismissed.
dismissed.
Appeal also dismissed.
Right.
Why? What were your grounds for ejectment? Defaulter.
defaulter bona fide.
What are the grounds of rejecting of dismissing the suit?
Pilot, started trial court held at the point of defaulter matter, they could not.
Okay,
And
and
bona fide requirement, they did not place.
bona fide was not pressed.
No.
And defaulter, what was the evidence?
Evidence, pilot, their case was that, pilot, it was the month-to-month tenancy, whereas, pilot, in the cross-examination part, they had accepted that it was on yearly basis. And they used to collect the rent as per their own concern. So the due date that, pilot, that was not confirmed. So as such, the court held that the due date is not confirmed, pilot, and it was the yearly tenancy and sometimes monthly also. So, pilot, the point of defaulter went, it's
Madam, slippery grounds. And that too in a revision. We grant you some time. If your senior wants to appear, let him appear. Okay. On the prayer of Ms. S. Musahari, learned counsel for the petitioner list. No. Ms. S. Musahari, learned counsel for the petitioner submits that though the matter has been listed for orders, it ought to have been listed for motion. Full stop. Sri A. Iqbal, learned counsel for the opposite party number, respond numbers.
Only one.
Respond one is present. Full stop para. Please for motion. After the vacation, immediately after the vacation. You want one of these days?
Pardon?
Do you want before the vacation? After the vacation, okay.
Under, before vacation, the last day of the Friday of the,
Let it come up.
We can have it because it's a new matter, whenever you say.
Right.
Friday?
Right.
Okay, on Friday. Oh, Friday, busy matter, need you. Let it be after the vacation.
Right.
Friday, this court has to rise early, okay?
of like,
CP of it.
34. None appears for the parties on call. Para, in the interest of justice, list after the summer vacation.
My lord, in this case, my lord, there is a 17 days delay. And the earlier occasion, my lord, respondent was on APR, but today that court is not shown the name.
Who's the respondent?
Mr. N. Dotto.
N. Datta.
Yes. He was a KPR referee. So, but
Okay, Sri R.C. Pal, learned counsel for the applicant, has drawn the attention of this court to the fact that though the respondent number 1 has appeared through counsel, comma, the name of the counsel is not reflected in the cause list today. Full stop para. List after the summer vacation
yes,
by
immediately.
by reflecting the name of Sri N. Datta,
Yes. Respondent
learned counsel for the respondent number 1.
so this is an application for condonation of delay of 4 days. Right? And the
Notice has gone.
But-
Notice was issued.
notice was issued. Respondent number 1 appeared, Lordship,
Who's
and
there?
3, 4 are the sons and
One
daughters.
SG Purkasta, where is he?
Name is shown in the cause.
Mr. SD Purkasta is regular, otherwise. Do Miss M. Chaudhary, learned counsel for the applicant, is present, comma, none appears for the respondent number 1. Do names
4.
shown in the cause list, full stop para. In the interest of justice, list immediately after the vacation
Lord.
to give another opportunity.
And so far as
Have
Lordship,
they filed objection?
no, no. So far as Lordship, respondent number 5 is concerned, he is owner cum driver. He did not appear before the trial. Ex parte order was passed against him.
Okay.
And the appeal is purely on content.
If you say so, we can. Ms. Chaudhary submits that the respondent number 5 is the owner cum driver
Lord,
against whom there is no liability in the award. Full stop. She accordingly submits that since the said respondent number 5 is yet to be served, comma,
it is not yet received. It is
yet to be since the report of service upon the respondent number 5 is inconclusive, comma, striking off the name of the respondent number 5 will not materially affect the adjudication of the present case, present appeal. Full stop para. But it is in the stage of delay condemnation.
Yes, Lord, the 4 days delay.
No, we'll hear it. Accordingly, comma, the name of the respondent number 4
Respondent
is
number
5 is struck off. Madam, we'll definitely condone this delay at the time of admission. Please point out this aspect. We'll strike off the name of the in the appeal also. Now, right now, we cannot pass any orders in the appeal. Okay.
First of it will come up for order.
It will still come up for order. The delay is yet to be condoned on presence of Mr.
Lord.
Forecaster.
This I is for condonation of delay of 52 days, in preferring time as test.
MFA against what?
Against the judgment and order of
Workman
Employees Commissioner Nagaula,
Okay. What is your name?
peaceable.
PJ Burman, huh? Itu kudijo pariba na notice, sir. How many days delay?
52.
52 days. Notice given. Steps by, you take by registered post with AD.
Yes.
Within 2 days.
Yes.
List after 6, huh?
Alright.
Along with service report. Okay, issue notice.
Please, for official dated 10/6/24 lordship. Dispatch number 1 is not served due to insufficient address. I located dispatch 1 and corrected the right address. Owner,
Madam, for
Respondent number,
file objection?
Yes.
You have filed?
no, my lord.
Okay. Part 3 AR Agarwala, learned counsel for the applicant. In this application filed under Section 5 of the Limitation Act, full stop. Miss S. Musari, learned counsel for the respondent number 2, praised for and is granted 3 weeks time to file objection, full stop. Para. So far as the respondent number 1 is concerned, comma, office note dated 10/6/2024 reflects that the address is insufficient and therefore the notice has returned unserved. Full stop. Sri Agarwala Learned Counsel for the applicant praised for and is granted 2 weeks time, 2 weeks time to take, no, a week's time to take further, to take fresh steps on the complete address of the respondent number 1.
corrected.
Full stop. Para. List after 4 weeks for objection by the respondent number 2 as well as for service report upon the respondent number 1. And 3 weeks, 4 weeks.
I
Yes,
for
Mr.
correction,
Correction of what?
correction of correction mistake is there. At page number 7, the last second line, MS number 01 of 2023, it should be MS number, manuscript number 01 of 2020.
This court's order.
No, Lord, this was passed by Honorable Justice A.M. Pujapur.
Okay. Yes, where is the document?
Lordship, at the main petition, at page number 12. Lord.
12.
Yes, main.
Okay.
Here also, Lordship, the case number is wrongly written.
So where is the fault of the court?
There is no fault of the court, Lordship. In my
Have you
court,
changed, have you corrected the main petition?
Lordship, in the main petition, it is already correct. In the order passed by the learned court, it is wrongly typed. But in my cost title, it's wrongly written. Sorry, rightly written.
Okay. Arbora,
Lordship.
Heart Sri Arbora Learned Counsel for the applicant who by means of this application has sought for a correction of the order dated 6/11/2023 passed in the connected CRP IU 346 of 2023, full stop. It is submitted that while considering and passing the interim order, comma, the proceeding of the case was reflected as MS number 01 of 2023, which should have been MS number 01 of 2022, full stop, para. In this connection, comma, the Learned Counsel has referred to the connected petition and has contended that even the impugned order passed by the impugned order dated 5/7 Is it 5-7?
5-7.
5-7-2023, passed by the learned court below, had wrongly stated the case to be MS-01 of 2023, as a result of which the said error has crept in the order dated 6-11-2023, full stop, para. Upon hearing, comma, upon hearing and on verifying the materials on record, comma, the instant application is allowed by directing that the reference to the case numbers, to the case number of the case number pending before the civil judge, West Karbi Anglong, is to be read as MS number 01 of 2022 instead of MS number MS 01 of 2023. Full stop. The said no, appearing twice, Gulikoba. Even in the first paragraph 2 also it's appearing. You have not pointed it out that. Paragraph 2, last line. Appearing on 2 occasions. Huh?
Okay.
Let this order be read as a part of the order dated since. Highest tense disposed of.
Okay.
Are you for?
Morning, in a matter, Your Lordship, remember the withdrawal of the suit.
Correct.
It's a connected matter. In fact, while the suit was survived, then an injunction order was passed by the learned court. That order was challenged by this appeal.
Okay. Now,
And,
suit has been withdrawn.
this honorable court is to stay the matter. Meanwhile, the suit was withdrawn. So therefore, the original miscase arising out of this case, that order, that become infractuous.
As per my instruction, my lord, the defendant number 7, they filed an application.
For transposing themselves as,
transposing.
yes, that has been
That is
done.
fine.
That has been done.
So, my lord, let it come after the application.
Because the plaintiff, whom my learned
Okay, he'll let him have some time. You are
Yes.
otherwise also there is a
It's not
protection.
today because my lord, I have
No, in fact, that is the subject matter of challenge. We have just passed an order this morning. Heard Sri B. Dotto, learned senior counsel assisted by Sri S. Deka for the applicants. Full stop. Sri A. Iqbal, learned counsel for the opposite party.
1 in,
Huh?
1 in.
1 and 2, opposite parties, party numbers 1 and 2. Submits that instructions are yet to be received. Full stop. He prays for and is granted 2 weeks' time to obtain the instructions. Full stop. List.
22, Your Lordship, that matter was fixed on 26th of July. 26th.
23-7.
Yes.
Okay. As requested by the learned counsel for the parties, list on 23-7-2024.
Interim order may continue to.
Here,
Yes, because that.
interim order passed earlier to continue to the last date of listing.
Until.
Deeply opposed.
Is it till until further orders?
It was still until
First order, Bharat. First order.
Not required to be
No, no.
accepted. Not like it. 26 it's on 26th, 7.
26/7.
My secretary is saying
So that it be on 23rd, Your Lordship.
it's already typed out.
Oh. No, this
This
back,
back.
this back.
This one, the one, along with
23rd.
separately.
Separate.
You want to come to Guwahati on 23rd
Yes,
For a marriage?
22nd,
for a marriage?
23rd.
Is it for a marriage? For a marriage?
Marriage, I am not invited till now.
No, then why do you want to come to Guwahati on 23rd? Okay. Even we are not invited to any marriage. Then maybe we just thought. Okay, 23rd.
Let the wish be came true, Your Lordship.
Not required. let everybody live in peace.
Thank you.
Keep your-
41, yes.
Wait, please, wait. My lord, my land was taken by the railway for railway line, my lord. So, my lord, I am entitled to an amount of rupees 11,14,848. But the authority paid me 9,29,004. So, my lord, less amount of rupees 1,85,887. So, my lord, my grievance before your lordship, without any reason that less amount has been paid. 1,85,808 amount.
You have filed the appeal.
My lord,
IA for what?
I am, my lord, I am main case is here, but main case is here. So here I have filed. My lord, during pendency of my appeal, they paid me 9,29,004.
Okay.
Now, my lord, your lordship would be pleased to turn to page 24.
Of the IA?
Yes, ma'am.
Yes.
Here they refer to a notification.
Hmm.
In this notification, my lord, it is provided that administrative cost and some charges can be deducted from the land acquired. Now, my lord, my question is this, that is to be paid by the railway, not by the landowner. Because, my lord, your lordship will take the reasoning. I did not approach that my land may be taken.
No, that is okay. Now, what
My
is
lord.
your prayer today?
My lord, my prayer is this, my lord, this less amount paid to me, 1,85,000, that may be paid to me.
This is the administrative charges.
Yes. So,
You-
my lord, my humble submission before your lordship will be page 10
Mr. Gogoi,
of my prayer.
which Gogoi?
But will be just otherwise of the digital amount also we have already deposited to the
No, Mr. Sheikh is pressing upon the aspect of administrative
so
charges.
that part.
He's saying that perhaps since it is a forcible acquisition of land where he had no role, rather he had objected to it, then in that case, why should we be burdened with the administrative charges?
That part, my brother have to. obtain
Mr. Gogoi,
otherwise.
T.R. Gogoi.
What was?
As
Have-
because of railway authority has.
Now, have you received the instructions?
No.
But-
That part.
Now, this has been levied by upon you by the administration or railways.
Now, my lord, railway sanction the amount.
No,
But
this
yet it-
part, 1,85,000
My lord,
of administrative charges has been levied upon you by the railways or by the administration?
Not by the.
by the administration. my-
Administration.
By the
They want to
administration,
expect from you, not from the
Yes.
railways.
Not from it. And, my lord, the relevant law, what has been
So you want to start a fight between two Gogois?
24. Your lordship.
We have already seen fight between two Gogois. No more fight.
Notification referred to a section. Here it is said that administrative charge will be taken, but not from me.
Yes, Mr. T.R. Gogoi, what do you say?
Lordship,
You take instructions. This is a matter where he is pointing out this, but ultimately the issue has to be settled between you two.
Lots.
Okay. If you, instead of him, if you extract from them, perhaps, then your friend, Mr. Gogoi, might have to say something. And he may be also right in contending that all decretal amount has been paid by him. So for administration, that is not a part of the decree. That cannot be. So
Right.
that's amount from whom do you get?
Part.
Okay. Have you filed anything here?
Only I.
You get the instructions, even if you don't file, we'll hear you. Okay. Hertz-free MSA Learned Counsel for the petitioner, who by means of this application has prayed for release. It has already been taken from you.
my lord.
This already deducted from you.
Yes, my lord.
Who by means of this application has prayed for release of an amount of rupees 1,85,808, which was deducted from him as administrative charges towards the land acquisition. Full stop. Para. Also heard. Sri K. Gogoi, Leonard Council for the Railways, and Mr. T.R. Gogoi for the T.R. Gogoi State Council. Full stop. Para. On the prayer of Sri T.R. Gogoi, Leonard State Council, matter is adjourned by 2 weeks.
2 weeks.
To enable him to obtain instructions as to instruction on the aspect as from whom the administrative charges are to be levied,
Administrative and other such.
administrative and miscellaneous expenses. As upon whom levied, no? As upon whom is to be levied. List after 2 weeks. Yes.
Master. May I pray for a date?
Yes, list on, we'll have it on 23rd, Tuesday. We'll have some time. Okay.
Lord, the petitioner is more than 90 years old.
He'll be alive till 20 next day. Don't worry.
All right.
Huh? We'll have 23rd July, Tuesday.
My pleasure. First of, I have filed by pro forma respondent to strike out the name of principal of main chair. If your lordship kindly peruse.
You're for?
I am the lordship, I am the applicant lordship, and main CRP, I am the pro forma respondent number 21.
This is whose application? Your application.
No lordship.
Your application, yes.
Lordship. What happened?
Why are you here? You should come this side. Why do you come this side?
CRP, I am.
Doesn't matter. He's the applicant here. Okay, no problem. Okay. What is your case?
What happened, lordship?
Mr. Ali would like to file objection.
No, lordship, if you are kindly peruse the case record of CRP, it can be disposed of today itself. Very simple matter.
No, your disposal means dismissing this application.
CRP, main CRP.
That is your easy disposal means dismissal.
Lordship, it can be disposed, main CRP.
Not the CRP, on the pro forma. You're on the main CRP.
Yes.
Main CRP can be disposed.
Yes.
Why?
It will help to understand both IA as
What
well as
happened in
my.
this lordship? The main case is between the pro forma respondent and petitioner lordship. The case is, main case is partition separation of share lordship. So what happened in this case lordship? Case is filed on 2014. And the
Partition suit.
yes lordship,
Then,
2014.
yes.
Evidence of PW is examined on 22/9/2016.
Hmm,
That is my evidence part.
hmm,
lordship.
hmm, hmm.
After that, they have taken time to file evidence of PW.
Okay. Okay, then.
Then your lordship, they have filed application another to another application. And recently, your lordship, they have filed a petition under order.
Mr. Ali, what is your prayer in the main revision?
If your lordship kindly peruse the plan for lordship, lordship will find annexure 1 in CRP, page number 13.
No, we will not have the CRP for disposal.
Lordship, original suit for partition between brother and sister.
Okay,
Lordship
of
knows very well.
2014.
Suit 14. Lordship knows very well, in a suit of partition, both plaintiff and defendant have equivalented. And Honorable Supreme Court as well as other High Court categorically held that if you are
Yes. Okay,
if your honor kindly peruse the judgment of Honorable Apex Court
yes.
at page 8. At page 8. Some part are highlighted.
Page 8.
Page 8.
Yes.
It is further been emphasized that in a partition suit, the plaintiff is not wholly dominus litis. And even on the assumption that Section 3 confers a privilege or an option on the shareholder who is the defendant in a suit for partition, the plaintiff is debarred from defeating the exercise of that privilege or option by restoring the device of withdrawing in a suit under Section 23 of Rule 20, Order 21, Rule 23, Rule 1. Lordship, even in a suit for partition, defendant can also withdraw suit. In another judgment, Lordship,
Yes.
this is the judgment of Honorable Calcutta High Court. If you're
No problem with that. Now, what is your problem?
But my problem is, Lordship, if you are kindly peruse the suit property, here two properties are there. Schedule A property that is situated at Dodora and schedule B property that is situated at Sanmai. Here both property are subject matter to the original.
Hmm.
In what happened, Your Honor, in the year 2021, some persons, that is present principal respondent number 1 to 19, suddenly encroach into the schedule A land, that is land situated at Dodora. And paragraph 3 to paragraph 6, I have explained all story, Lordship, regarding encroachment by that person on 9/3/2021 initially and started to construct a temple. And thereafter, finally, on 21/3/2021, they have dispossessed and encroached into the land. After that incident, although I repeatedly communicated to the plaintiff, to the ordinal, so it is pro forma defendant to this proceeding, that this is joint property. We have also equal right. That person should be included in the suit. Otherwise, Lordship, after passing judgment and decree, that decree cannot be executed if they are not included in the suit.
No, that will not be a suit for partition then.
Yes,
If encroachers are to be evicted,
Yes.
that cannot come within the ambit of a partition suit.
Yes,
It will be a separate cause of action.
And also we are the best case, we are the plaintiff, and plaintiff cannot be forced to make the part, plaintiff cannot be forced to impede parties against, they have not.
No,
they-
Mr. Ali, you may be right. If you had contended that there are other properties which were not the subject matter of the suit.
Yes, sir.
Suppose in a given case, in a partition suit, there are more than one property and only one property or few properties are made the subject matter, yet there are other properties. You can take a valid defense that there are other properties, you should have a whole claim. Now here, the cause of action is wholly different. There are two scheduled properties.
Yes, sir.
One at Dodora, one at Chanmari. The Dodora property was encroached by a third party.
Yes.
And whether that relief can be incorporated in a suit for partition.
No, Lord,
Is it connected? It is not
not
connected.
connected.
What happened? Yeah.
Now, what is your revision about?
My revision, I filed an application under order
One
rule 10.
Their petition is
With a
rejected.
prayer to issue notice that person,
Those persons.
persons,
You are a
uh,
pro forma defendant in the suit,
in the suit, I am principal defendant.
principal defendant.
There is no format defendant, Lord.
That I prayed to.
You are also the brothers and same siblings.
Yes.
You prayed for addition of parties.
Those
Yes,
persons.
okay, you have your status is almost at par with the plaintiff
Yes.
in a suit for partition, no problem with that proposition. But the relief you are seeking for implement of a party is not of a party who is a connected party in a partition suit. He is a party against whom a different cause of action may lie for evicting him if he is an encroacher.
Then I will have to file a
Separate suit,
Then it will
separate
cause.
suit. No, it's not a question of multiplicity, it's a different cause of action together. How can you have a eviction in a partition suit?
If your Lordship kindly peruse the plan, they earlier incorporated all the tenants resides in Chanmari property. That's because they are also interested being possessor of the same. If that's so, that being so, yeah.
No,
Lovely.
the position of a tenant who is a permissive possessor.
Yes.
And those of an intruder. For him, you need to have a decree of eviction.
Lordship, all those tenants
Tenant,
are
there will be
party.
other connotation because tomorrow who will be the landlord?
Yes.
Tenant has to know
Yes.
whom I'll pay the rent. But for an outsider who is entered into the land forcefully, that's a different cause of action.
Then I may be give liberty to file to separate.
You have
Sure.
all the liberty.
Then I may be allowed to withdraw the proceeding with the
Okay.
liberty.
Okay,
File.
okay. I will, okay. Third, Sri R. Ali, Learned Counsel for the petitioner.
Sorry, Lordship, if your honor, out of those person, 2%, that is respondent number 17 and 19 filed their affidavit in opposition. Here they have stated that that property was belonging to them by way of a registered gift. Ultimately, those persons own their interest
Okay.
over the property.
This respondent, they are the intruders or what?
Yes, 17 to 19.
They are what the parties who have intruded upon the encroach upon the lands.
Yes,
They say that we have entered by way of a registered seal deed
register gift,
or gift deed
gifted
by
by some other person.
some other.
At
then
least
it
to be
is
executed in the year
a separate cause of action.
19.
Then you have to challenge the gift deed. You know what to do. Learned counsel for the petitioners who by petitioner also heard Sri
T.
uh,
Sharma.
T. Sharma.
T. Sharma.
P. Sharma. Learned counsel for the respondent numbers 20 and 20,
20,
20 or
21,
20, 22, 22, huh? 20 Bisharra Vice. The though the names of respondent numbers of the learned counsel for the respondent numbers 1, 2, and 4 appear, comma, none is appearing. No, it appears no, is reflected in the cause list, comma. There is no representation. Full stop. Para. Please have your seat. The application has been presented under Article 227 of the Constitution of India, challenging an order dated 30/11/2022, passed by the learned civil judge number 3, Kamrup within bracket M, in Ms. J case number 198 of 2021, arising out of title suit number 116 of 2014. Full stop. Para. The suit was instituted by the respondent numbers 20 to 22 as plaintiffs for partition, in which the present petitioners were defendants. Full stop. Defendant numbers 1 and 2. Full stop. In the said suit, comma, the defendant numbers 1 and 2, who are the present petitioners, had filed the aforesaid Ms. J case 198 of 2021 for implement of parties by invoking the provisions of Order 1, Rule 10(2) of the Code of Civil Procedure. Full stop. The learned court, however, by the impute order dated 30/11/2022, had dismissed the suit, and accordingly, the present application has been filed. Full stop. Para. Sri Ali, the learned counsel, has submitted that that the suit being a partition suit, comma, the position of the defendants would be at par with that of the plaintiffs. Full stop. In this connection, comma, the learned counsel has referred to a decision of the Honorable Supreme Court in the case of R. Ramamurthy Iyer versus Raja, reported in AIR 1973, Supreme Court 643. Full stop. In the said case, comma, the Honorable Supreme Court has reiterated that in a partition suit, comma, the plaintiff is not the sole dominus litis, and a defendant who is a stakeholder, who is a stakeholder in the property would have the equal rights Full stop. Para. On the other hand, comma, Sri Sharma, the learned counsel, for the contesting respondent numbers 20-22, has submitted that the inclusion of the parties, the parties who are sought to be included are not the family members or having any interest in the partition suit, but they claim to have acquired the right title and interest on the basis of certain gift deeds. Full stop. He submits that in any case, comma, any issue arising out of such forceful possession has to be raised separately and not in a suit for partition. Full stop. Para. Though there is absolutely no dispute with the proposition advanced by Sri Ali on the rights of a defendant in a partition suit, comma, in the instant case, comma, it appears that the reason for which the implement of new incumbents was filed was on the basis that those incumbents had encroached upon the land on the basis of some gift deed. Full stop. Para. In the opinion of this court, comma, the issue which has been sought to be ultimately raised by implement of parties is to challenge the is on the cause of action of forceful possession of such by such incumbents, which may be by certain deeds. Full stop. In a suit for partition, comma, challenge to such deeds may not be permissible or even proper. Full stop. Para. Accordingly, comma, this court is of the opinion that the impugned order dated 30/11/2022 passed by the learned so-and-so in Mizje case number so-and-so does not call for any interference. Full stop. However, comma, the petitioner would be at liberty to institute a fresh suit to espouse the cause of action, including challenge to the gift deeds, which may be the basis of such intrusion in the Schedule A property of the suit.
One prayer is that the next date on 9/7 for necessary order. Actually fixed for evidence because we have trial already.
Will not have the interim order accordingly stands vacated.
No,
No
there
interim
is no interim order because already
The trial court would proceed expeditiously as the suit is of the year 2014.
obliged.
I had to hear you. I had to hear that. In view of the final orders. So I stand disposed. I was about. Okay.
May I please, your lord, have to delay application listed the first time.
Okay. Delay condemnation notice করে দিবা হ্যাঁ ডি মন্ডল against দেখি notice করে দিবা আর steps by registered post to ready within 2 days. After 6 weeks along with service report.
Highly obliged.
Yes, 44.
First time 38 days delay.
38 days, it will like it. RC Paul. steps by registered post TD, within 2 days, 6 weeks for report.
Asur.
Yes. Delay condemnation.
Delay condemnation.
What is your name?
Aspect.
Aspect, okay. 49 days delay. Delay block over Likiba. Section 5 Bulikova. In what? By the commissioner, employees compensation. Okay. You take steps by registered post TD within 2 days, 6 weeks for report.
All right.